I'm being harassed by the star of Sperm Splattered 4. So, there's that. Sperm splattered and baby battered. That's right. Madison Marquette.
What you think about when you're born into a fire? Let them burn it out. Sell them to the richest buyer. They wanna let
Yeah, I have a birthday, Ollie. Ryan makes me play a plumber sometimes. And Lavada always wants me to break in.
Because we're never dropping out. Beat the odds, beat the big house. The brains are bigger than the doubt. We've been thinking for ourselves. Never let the truth fade away. This is bigger than ourselves. We won't let the world burn away. Burn away. We feel betrayed. We were raised to lose the race. Wake at the back of the pack. Kill it anyway. To play. Haters face the world's mistakes. Wake at the back of the pack. Kill it anyway. And we feel betrayed. We were raised to lose the race. Wake at the back of the pack. Kill it anyway. To play. Haters face the world's mistakes. Wake at the back of the pack. Kill it anyway.
I'm about to get kicked out of my mom's house, I think. Over these liens. Misspelled. Over these liens. About to get kicked out of mama's house. Lavada's gonna receive a notice as well. Anyways, that's the music. That's the timer. Let's go.
Hey daddies, it's me, the Linda Binda from TikTok. I wanted to make this video because I wanted to thank you for watching Cold Beer Confessionals with Will Bird. I think that's just incredible. I've watched a few episodes and I'm just like very intrigued. But you know what I'm most intrigued in is Big Daddy's meat stick. I heard that it's very thick, like a good old German sausage. You know, Linda and her coochie loves that. Oh, never mind. Let's not go there. Anyways, I hope you have a good show and enjoy it as you can. There's a lot of weird things that go on, especially when it comes from the realm of Linda Bindaland. So, enjoy the show. Thanks for watching. Peace out.
Welcome, everybody. I'm Will Bird. This is the Cold Beer Confessional. Thank you for joining us. I am being harassed by the star of Sperm Splattered 4. If you haven't seen my Twitter account, Madison Marquette's coming after us. Me, Lavada, my one kid, my mom, who I live with. Just got us all dead to rights. We're going to lose everything. We're going to lose everything, I think. But that's not what we're talking about tonight. That dumb bitch can wait. She's got enough baby batter smeared across her face where she can live on it for a while. Tonight, we got fill documents. The new documents came out last night to get to them. So we've got them tonight. That's probably all we'll do because I don't want to keep it too long.
But wait till it get home. She gonna be like, damn, shit, my God.
I refuse to buy Derek J's paperback. 9 cents for $45. Rather it go to a good cause. So suddenly we're a good cause? I thought we were a charity based on hookers and cocaine, but I'd rather go to a better cause. Go to a better cause, not a good cause, a better cause. Also, happy birthday, Ollie. Thank you very much. I appreciate it. Let's see what we got. Phil Godlewski. Also, Jordan Saylor bought a 6-pack. Pivotal work exposing clickbait scum. Your work helps me keep track of these fraudcasters too. A tip for your travels. Thank you very much. Let's see. We got Phil Godlewski documents. That's probably all we'll do. I like to keep it like short and sweet when we got Phil shit. That way it wraps back around to more people will watch it, right? If I do like a 4-hour stream and it's buried in a stream, less people will watch it. So I've already got them opened up. That's what we'll start at. If you want to support the stream, you guys know how to do it. Coldbeer.fund. Coldbeer.fund. Use one of the links there. You can make a contribution to keep the stream going. That's how it works. Coldbeer.fund. F-U-N-D. Let's see here. Where are they at? Oh, hold on. Let me close some of these extra bullshit things that are open. Okay. Now, this isn't a ruling. This is a brief in support of a motion. So the Scranton Times filed a motion for summary judgment. Summary judgment is after discovery when the case is about to start. Someone goes to the judge and says, "Hey,
Barber Antique gifted Dolls 234 a subscription.
Thank you for
Barber
the gifted
Antique
sub.
gifted a tier 1 sub to Dolls 234. They have given 7 gift subs in the channel.
Thank you." This is when the one side goes to the court or goes to the judge and says, "Look, they didn't meet the basis of the case. They have no evidence. They have no witnesses. They have no whatever. And how about just going ahead and ruling?" And that's basically it. So the Scranton Times, we saw their motion last week that they were doing a motion for summary judgment saying he's refused discovery. He hasn't played along. He's lied about this, lied about that. You can't trust him to be honest. He already admitted to having sex with her. He admitted guilt to this. This is what the Lackawanna County DA said. Now, this is the document that's going to explain all that, basically. This is the document that's going to explain that. So they filed the motion, and this is their brief in support of motion for summary judgment.
Got a small dick, but wait till it get home. She gonna be like, damn, shit, my God.
Jennifer Winkler bought you 10 6-packs. Thank you very much, Jennifer. Yeah, Madison texted me today, and she said something like, "Just wait, I'm headed to Tennessee." And I said, "I think I'll relax a little bit once one of your old videos and rub one out." She did not appreciate that. Weird. Procedural history, background statement, questions presented. Statement of the questions presented, the argument, and the conclusion. It's 69 pages. I'll try to hang on my voice for that long. Usually, it gets pretty excited, and then by the end of that, so here's all the case law they're citing. By the end of that, I'm usually pretty tired, wore out. Defendant's brief in support of motion for summary judgment. Defendant Chris Kelly, here and after Kelly, and the Scranton Times LP, here and after Scranton Times, collectively defendants. Now, notice it doesn't say Larry Holeva anymore. They had to release Larry Holeva from the lawsuit. They had to release Larry Holeva
Anonymous
from the lawsuit.
gifted Robin Angel 1 a subscription. An anonymous user gifted a tier 1 sub to Robin Angel 1.
Hold on just a second. Thank you for the gifted sub. Defendant, they had to drop Larry Holeva. He's no longer in the suit at all. By counsel hereby, file this brief in support of their motion for summary judgment, seeking judgment as a matter of law on all claims presented by plaintiff Philip Godlewski plaintiff or Godlewski, pursuant to Pennsylvania Rule Civil Procedure 1035, and state as follows. Procedural history. Godlewski filed a six-count complaint on May 2nd, 2021. The lawsuit is based on the opinion column authored by Kelly, which was published in the Times-Tribune newspaper on February 14th, 2021. This opinion column shall be referred to herein as the article, and a true and correct copy is marked as Exhibit 1. All the exhibits referred to herein are included on the exhibit list for brief in support of motion for summary judgment, and the exhibit list, along with the exhibits, shall be filed as a separate document. There are numbers assigned to each paragraph of the article for reference purposes. Count 1, plaintiff's complaint asserts defendants defamed him based on one factual averment. Defendants made a statement of fact in the newspaper article that Godlewski had sexual intercourse with a 15-year-old girl. Count 2 asserts a defamation claim based on Godlewski's reputation as a realtor. Plaintiff claims the article depicts him as being involved in QAnon and not fit to sell real estate, and as a child molester with no credibility. Count 3, plaintiff was defamed because the article implies he was involved in the insurrection at the U.S. Capitol on January 6, 2021. Count 4 asserts a false lie invasion of privacy claim, but includes no alleged facts. Count 5 asserts an international interference with, or intentional, I don't know why I said international, an intentional interference with plaintiff's existing contractual relations as a realtor by publishing a defamatory article about him. Count 6, mistakenly referred to as Count 5 in the complaint, pleads, he didn't even get the numbers right, pleads a claim for the intentional interference with plaintiff's prospective contractual relations as a realtor. Defendants filed an answer and new matter to plaintiff's complaint. The pleadings are closed. Defendants undertook comprehensive discovery, including 9 depositions and several set of written discovery requests. Plaintiff conducted limited discovery, which included 2 depositions and written discovery requests. The court entered a case management order on July 11, 2023, which closed discovery as of December 31st, 2023, and compelled defendants to file their motion for summary judgment by January 31st, 2024. On January 22nd, 2024, the court entered an order and opinion sanctioning plaintiff for failing to preserve and produce his text messages requested in discovery. So that was the last one we saw, where they said they were going to seize his phone. They asked for the case to be dismissed, which is a long shot. But the court is like, obviously he either lied about these text messages or deleted it, or didn't, either lied and deleted them or didn't have due diligence to save them for the court case, because he was informed. He was told he had to have them. The judge even had to break it down for him, like what a message is, what it isn't. A screenshot of a message counts as a message. The judge broke it down for him, and he still fucking deleted shit and claimed he didn't have it, and then suddenly come up with it and lied to them the entire time. Okay, let's go. The parties have entered into 3 stipulations which have been approved by the court and adopted into orders of court. On January 18th, 2023, the court entered an order stating, for purposes of this litigation, plaintiff Phil Godlewski shall be deemed a public figure. Also on January 18, 2023, the court filed a separate order declaring that plaintiff's claims for economic or special damages are dismissed with prejudice, so he can't bring those back again. So the reason that this public figure is going to come into play later on is because I told you the way the law is written, if you're a private citizen, the people that make the claim have to prove it's not true, or it is true, or their claim was accurate. If you're a public figure, you have to prove that they should have known it was not accurate and still acted with actual malice. They had to dismiss the, he wouldn't turn in his tax returns or tell how much money he made, so they had to dismiss the economic or special damages are dismissed with prejudice, and he can't bring them back up. He wouldn't disclose how much money he made. He just said he made more. On January 2nd, 2024, the court entered an order dismissing Larry Holeva from the case. So that's when January 2nd, 2024, just this year, he was released. Godlewski complaint, paragraph 1. It should be on Rumble. Yeah, it's on Rumble. Summarizes his claim against defendants. He accuses defendants of defaming him in the article by stating, 1, he had sex with a 15-year-old. 2, he's a purveyor of poison. who curdled the hearts and minds of millions who may never recover. 3, he was involved in the seditionist mayhem at the U.S. Capitol that resulted in 5 deaths. 4, plaintiff is an unreliable and unethical realtor who misrepresents the properties he sells. Back in 2011, plaintiff pled guilty to corrupting the morals of a minor female. Godlewski was more than 10 years older than the victim. Godlewski was charged with various crimes alleging a sexual relationship with this minor. He negotiated a guilty plea whereby all charges were dismissed in return for his guilty plea to the corruption charge. Plaintiff has admitted this was a plea bargain. This was a plea bargain. Not they dropped all the charges. Not they didn't have evidence for the charges. It was a plea bargain. A true correct copy is here for the deposition 7/25/23. On the day after Godlewski was sentenced on the corruption charge, July 12th, 2011, the headline in the Times Tribune newspaper read, ex-baseball coach sentenced for sex with girl 15. A true and correct copy of the 7/12/2011 article is included in the exhibit list and marked as Exhibit 3. In 2021, plaintiff launched a new career as a social media broadcaster and leader in the QAnon movement. He calls himself a truther and a patriot reporter. He quickly gained thousands of followers who watch his live video shows on the Q movement, election fraud, flat earth theory, and a host of conspiracy theories. A principal tenet of the QAnon movement is that the world is run by a cabal of Satan-worshipping pedophiles. The irony of plaintiff being a popular QAnon conspiracy broadcaster was not lost on Kelly, since plaintiff had been charged with numerous sex crimes against a child and he pled guilty to corrupting a minor. After the lawsuit was filed, Godlewski tried to bribe the minor victim to get her to say she was 18 when she had sex with him. He sent her text messages offering her a unique financial opportunity, but cautioned her that the matter must be handled properly by both of us. A true and correct copy of the herein referenced text message between Bree and Godlewski from 5/28/2022, 8/5/2022, 8/6/2022, and 8/18/2022 are included in the exhibit list marked as Exhibit 4. Plaintiff even teased his social media followers when he posted, "What is everyone to say when the victim testifies during my Scranton Times lawsuit? What is she going to say? I have a feeling the truth is going to be revealed." See, Godlewski's August 6th social media post is included in exhibit list and marked as Exhibit 5. After this post, plaintiff met the victim and she refused his $50,000 offer. A true and correct copy of the script is included in exhibit list marked as Exhibit 6. Instead, she contacted defense counsel to tell the truth about Godlewski. Bree, hereinafter referred to as a minor victim, or Bree, executed an affidavit stating she was involved in a sexual relationship with Godlewski when she was 15 years old and he was 25. A true and correct copy of Bree's affidavit is included in the exhibit list and marked as Exhibit 7. Further, she provided defense counsel with her text messages with Godlewski from 2021 and 2022. After the victim's affidavit was produced to Godlewski, Godlewski sent the victim this text message. Bree, I'm going into the next Trump administration as a political advisor, intelligence figure. My public persona is going absolutely nowhere. In fact, it's accelerating rapidly. There might be 10 million that know me now, but there will be 300 million that know me 5 years from now. And I have to deny. I could have instead praised you for your honesty and called you a lifelong friend in front of millions. But you signed that affidavit. You see it now? This gets worse, not better, way worse. That sounds like a threat, to be honest with you. Sounds like a threat. A true and correct copy of November 22nd. This was after he figured out she had signed an affidavit against him. After. Ollie feels like a celebrity. A true and correct copy of the November 2022 text messages included in the exhibit list, marked as Exhibit 8. Godlewski produced this text message after the sanctions hearing on February 6, 2023. Plaintiff then took to social media to threaten a lawsuit against her. A true and correct copy, Exhibit 9. He privately hounded Bree to recant her first affidavit and claimed she was intimidated and extorted by defense counsel into executing the affidavit. Godlewski wrote to her, "It all goes away, Bree, once the affidavit goes." Is he fucking retarded? So literally, right after she goes to the defense counsel, he's still messaging her. It all goes away. If you just say the right thing, it all goes away. Once the affidavit goes away, it all goes away. Is he fucking retarded? And adds, "You'll have my lawyer," saying he will pay for her legal fees. That's Exhibit 10. Statement of the questions presented. Has plaintiff, a public figure, presented sufficient evidence to prove defendants made false statements about him in the article? No. Has plaintiff presented clear and convincing evidence that any false statements in the article were published with actual malice? No. That's a standard because he's a public figure. Are the statements in the article about plaintiff spreading lies and being involved in QAnon defamatory? No. Are certain statements in the article concerning plaintiff's criminal case subject to fair report privilege? Yes. Has plaintiff produced sufficient evidence to prove harm to his reputation for his defamation claims? No. He's hardly produced any evidence at all. The shit they requested, that was it. Should plaintiff's claim for false light invasion of privacy be dismissed since plaintiff lacks evidence of the essential elements of the case of action, or of the cause of action, and he cannot prove actual malice? Yes, they should be dismissed. Should counts 5 and 6 of the complaint be dismissed since plaintiff claims for economic damage have been dismissed and he otherwise lacks evidence to prove these claims? Yes. Does plaintiff have sufficient evidence to recover punitive damage? No. He hasn't presented anything. For some reason, the way Phil thinks court works is like a fucking TV show where they just go to court and like you think this guy's guilty, then all of a sudden everybody gasps and somebody walks through the back door and they're like, I'm the witness. Everybody, you didn't know about me. Like everything comes out in discovery, you fucking retard. And you didn't present anything. Pennsylvania courts have repeatedly acknowledged that the motion for summary judgment has an important function in the context of a defamation case. Defamation against a public figure and the actual malice clause is near impossible to prove. Even the Pennsylvania Supreme Court says it's almost impossible to prove. Almost impossible to prove the actual malice. You have to prove that they fucking knew they were lying and they just fucking hated you anyways and lied. Who the fuck does that? Well, Madison Marquette, but who else does that? Well, Phil, but what journalist does that? Summary judgment is appropriate, one, whenever there is no genuine issue of any material fact as to the necessary element for the cause of action. Two, if an adverse party who will bear the burden of proof at trial has failed to produce evidence of facts essential to the cause. So Phil has had this wrong the whole time. He keeps saying the burden of proof is on the Scranton Times. The burden of proof is on Phil Godlewski. He has to prove that it didn't happen. They should have known it didn't happen or did know it didn't happen and still proceeded with disregard for the truth or actual malice. Burden of proof trials produce evidence of facts essential to the cause of action. Once the motion for summary judgment has been properly supported, the burden is upon the non-movement, Phil, to disclose evidence that is the basis of his argument resisting summary judgment. The entry of summary judgment. So because they filed this, they're the movers or the movement. They put the motion in. They're the movement. And Phil would be the non-movement. The entry of summary judgment in favor of the defendant and against the plaintiff is appropriate when the plaintiff is unable to present evidence of an essential element of claim on which the plaintiff bears the burden of proof. For a non-moving party to survive summary judgment, it must adduce sufficient evidence of an issue essential to his case and on which he bears the burden of proof such that a jury could return a verdict in his favor. So you have to prove there's even a chance that based on the elements of the crime, not based on how you feel about it, not based on how your followers feel about it, not based on the lie you told to this person or that, based on the elements of the crime. Like several crimes, like you have to do this, you have to do this. They just something like illegal possession of a firearm across state lines. So you have to have possession of a firearm. It has to be possessed illegally, and you have to cross state lines from one state to another, right? So you have to meet all three of those. You could still have illegal possession of a firearm. You can still have crossing a firearm or crossing state lines with a firearm. But you got to have all three of those to meet that tenet. So he has to prove that it didn't happen, that they should have known it didn't happen, They didn't know it didn't happen, and they proceeded with actual malice. So he has to show proof that all these tenets were met or could be met in the eyes of the jury. The moving party is not required to introduce evidence on an issue on which it does not bear the burden of proof in order to have its motion granted. So they don't bear the burden of proof. They don't have to prove that he did it. These requirements are equally applicable in cases involving claims for defamation, as confirmed by the United States Supreme Court in Anderson versus Liberty Lobby, Inc. The Anderson court explained in detail the burden of a non-moving party in resisting a motion for summary judgment on its defamation claim. This is a quote from the case text. Just as the convincing clarity requirement is relevant in ruling on a motion for directed verdict, it is relevant in ruling on a motion for summary judgment. So you have to provide at least if the judge looks at this and says, I don't see any possible way that you can present evidence based on the evidence you got here. I don't see any possible way that you could win this case. Then you have to give the judge what they call convincing clarity. Enough clarity to where he thinks, yeah, I guess a jury could say, they did this, or could rule in your favor. Sure. When determining if a genuine factual issue as to the actual malice exists in a libel suit brought by a public figure, a trial judge must bear in mind the actual quantum and quality of proof necessary to support liability under New York Times. For example, there is no genuine issue if the evidence presented in the opposing affidavits is of insufficient caliber or quantity to allow a rational finder of fact to find actual malice by clear and convincing evidence. Actual malice by clear and convincing evidence. Thus, in a ruling on a motion for summary judgment, the judge must view the evidence presented through the prism of the substantive evidentiary burden. Anderson, 477 U.S. at 24255, as set forth in detail below, the higher standards of convincing clarity or clear and convincing evidence applies to both the New York Times requirement of proving actual malice and the HEPS requirement of proving falsity. B, plaintiff has the burden of proof, to prove defendants made false statements about plaintiff in the article. In libel actions against a media defendant for publications on matters of public concern, the First Amendment requires the plaintiff bear the burden of proving that the publications are false. Philadelphia newspapers versus HEPS. See also Lewis versus Philadelphia newspapers. Appeal denied. If the statement in question bears on a matter of public concern or the defendant is a member of the media, First Amendment concerns compel the plaintiff to prove as an additional element that the alleged defamatory statement is in fact false. Again, because he deals with the public on a regular basis, this is a public concern. And if this is a public concern, or if this is a member of the media, you have to prove what they said was false. Not the other way around, Phil. You've been wrong since you filed the fucking case. In HEPS, the Philadelphia Inquirer published a series of 5 articles about a grand jury investigation in the connection of Mr. Hepps and his business to organized crime. The newspaper relied on confidential sources and, under Pennsylvania Shield law, is refused to disclose the identity of those sources to the plaintiffs. Mr. Hepps had prevailed under Pennsylvania law, which did not require a plaintiff in a defamation case to prove falsity, but rather recognized truth as an affirmative defense to be proved by the defendant publisher. United States Supreme Court, however, so it says in Pennsylvania, that he won and said, hey, the newspaper can't prove that this is true. But the Supreme Court stepped in and said, switch the burden in the cases involving public concern, finding that the newspaper prevailed because the plaintiff could not prove it was false. So they're laying the basis for all of this, the way the laws are written. United States Supreme Court recognized in HEPS that there was a category of defamation claims when the fact-finding process will be unable to resolve conclusively whether the speech is true or false. It is in those cases that the burden of proof is dispositive. HEPS presented the classic example of such a case. Because grand jury investigations are secret, it is unlikely that anyone can conclusively prove what transpired before the grand jury. The Heps Court reached the result with full recognition that Pennsylvania shield law makes it more difficult for plaintiffs to meet the burden of proving falsity in cases involving the media reporting on matters of public concern. The article here falls squarely within the Heps Court reasoning, as it involves a newspaper defendant reporting on a matter of public concern. Whether speech addresses a matter of public concern must be determined by its content, form, and context, as evidenced by the entire record. That's from the American Future System versus Better Business Bureau. Matters of public concern are those which contribute to a robust debate on public issues. The article clearly qualifies as a report on a matter of public concern, as it discusses the growing QAnon movement and its relation to January 6th riot at the Capitol. The QAnon movement has been widely reported on in publications and media outlets such as the New York Times, Wall Street Journal, BBC, CBS News, Pew Research Center, CNN, NPR, and AP News. The United States Supreme Court has declined to rule on whether Heps requires a plaintiff to prove falsity by clear and convincing evidence or under lesser preponderance of the evidence standard. See Hart Hanks Communication Inc. versus Connaughton. A majority of federal and state courts have concluded that falsity must be established by clear and convincing evidence. We also observe that many jurisdictions outside of New York have considered the issue have found that clear and convincing proof of falsity is required for public figures and sometimes even private figures. See the Worldwide Association of Specialty Products versus Pure Inc. Noting that the Second Court recently observed that the majority of state and federal courts apply the heightened clear and convincing standard to the element of falsity. The heightened clear and convincing standard is particularly appropriate where public figure sues a media defendant over a matter of public concern. A clear and convincing standard of proof for falsity would resolve doubts in favor of speech when the truth of a statement is difficult to ascertain conclusively. Indeed, as a practical matter, public figure plaintiffs already bear such a burden, for in order to prove actual malice, they must, of necessity, show by clear and convincing evidence that the defendant knew the statement was false or acted in reckless disregard for its truth. Finally, the standard has more than merely a logical or symmetrical appeal to instruct a jury that a plaintiff must prove falsity by the preponderance of evidence, but must also prove actual malice, which to a large extent subsums the issue of falsity by a different and more demanding standard, is to invite confusion and error. Plaintiff definitely has a burden to prove falsity here, and that burden should under the clear and convincing standard of proof. Should be under the clear and convincing standard of proof. Statements in the article regarding plaintiff having sex with a minor. Plaintiff claims defendant's statements about him having sex with a minor and admitting to sex with a minor as part of his guilty plea are false. Those statements are contained in paragraphs 21 through 26, or 21 through 22 and 26 of the article, which have been copied below for easy reference. Here's proof. In the normal course of reporting this column, I stumbled upon some legal troubles in Godlewski's recent past. In 2011, the former Riverside High School baseball coach pleaded guilty to corruption of minors and admitted to having a sexual relationship with a 15-year-old girl. Lackawanna County detective said Godlewski had sex with a girl in cars and homes he had access to as a real estate agent. Godlewski, 28 at the time, was sentenced to 3 to 23 months, with the first 3 months to be served under house arrest and the balance as probation. In fact, my editor and I discussed whether to include this information, which is public and was previously published in the Times Tribune. We decided it was relevant in regards to Godlewski's credibility. I have many character defects, but the last time I had sex with a 15-year-old was never. Never. Exhibit 1. There is no dispute that Godlewski pled guilty to the corruption charge, and the detective said Godlewski had sex with a girl in cars and houses which were up for sale. A true and correct copy of plaintiff's response to defendant's interrogatories, set 2. Number 1 is included in the exhibit list and marked as Exhibit 11. See also Exhibit 2, pages 216 and 219. Godlewski admits he did, in fact, corrupt the morals of the minor victim. Exhibit 2, page 108. No liability can attach for true statements. See American Future Systems, Inc. and Better Business Bureau of Eastern Pennsylvania. The only issue here are whether Godlewski can prove he did not have sex with a minor victim and he did not admit to having a sexual relationship with a 15-year-old girl as part of his guilty plea. 2010-2011 criminal case. Godlewski was arrested pursuant to 8-count criminal complaint by the Lackawanna County District Attorney's Office on July 9, 2010. A true and correct copy, Exhibit 12. Godlewski was charged with statutory sexual assault, involuntary deviant sexual intercourse, aggravated indecent assault, unlawful contact with a minor, corruption of minors, and indecent assault. All 6 charges were based on Godlewski's sexual intercourse with the minor victim. All 6 of these charges were based on Godlewski's sexual intercourse with the minor victim. Godlewski's date of birth is June 1983, and Bree's date of birth is September 1993. Godlewski was also charged with intimidation of the minor victim and a witness at a criminal use and communication facility. The intimidation charge is based on Godlewski instructing the minor victim to tell law enforcement all the text messages he had with the victim were fake. He also told the victim that she is the only person who can get him out of these charges. Godlewski told a witness, Thomas Neslow, who was also charged with having sex with the minor victim, to contact the victim to get their story straight. Exhibit 12. A true and correct copy of Neslow's affidavit is here. Exhibit 13. The affidavit of probable cause is here. Exhibit 12. It stated Detective Mancuso met the minor victim at the Child Advocacy Center on March 19, 2010 to conduct a forensic interview. The victim was accompanied by her mother, Linda, and her father. The victim told the detective she had been involved in a sexual relationship with Godlewski starting in 2008. The victim turned 15 in September of 2008. According to the detective's affidavit, the victim reported she and Godlewski engaged in oral and vaginal intercourse. An additional page of the affidavit of probable cause included various communications Godlewski had with the victim when she was 15 and 16 years old. Exhibit 12. The affidavit of probable cause stated, on 2/25/2010 at 22:35 GMT time, Philip Godlewski, his phone number stated to the victim, I just want you to see that I really care about you and not your body or our sex. Maybe that's the only way I can. 2/25/2010 at 22:38 GMT. I need you, Bree. I need you more than anything in my life. I'm going to do everything I can to be with you as soon as I possibly can. And you're my drug and I'm addicted, to quote a dear friend, Cy. On 2/28/2010, 1922 GMT, Godlewski states, the only way we'd ever be sexually satisfied is if we did it like 4 to 5 times a day. 36/2010, 22:08 GMT, Godlewski, I hate my penis. I don't know why the fuck that happens. You look so good and you were given incredible head, then boom, gone. Like, what the fuck? Godlewski typed a two-page day log with times and entries. Godlewski then gave this log to the victim. The day log includes a detailed account of his activities and thoughts throughout the day. The following are excerpts from the day log. 10:14, realized that you're only 15, but quickly stopped caring. 10:34, got sad because we can't officially go out. I just want everyone to know that I love you. 11:39, I just pulled Bree hair from my crotch area. Ha. 2:56, should we get a jacuzzi suite? 3:56, why can't you be 21? 5:28, why are we so compatible? I'm 10 years older than you. Talk about incriminating yourself. The 4 text messages referenced above were taken from the text message attacked to Bree's second affidavit dated March 28, 2023. A true and correct copy of Bree's affidavit is Exhibit 14. Godlewski also handed Bree a 2-page day log around Christmas 2008 with some Christmas presents. Exhibit 14. Pennsylvania State Police downloaded Bree's cell phone on March 22nd, 2010, and were able to capture 17 days of text messages between the minor and Godlewski from February 24, 2010 to March 12, 2010. The captured text messaging on March 12, 2010, which fits in with the Pennsylvania State Police form that notes the cell phone was put into Taylor Police Department's possession on March 13th, the next day. The prosecutor who handled the criminal case against Godlewski was Patricia Lafferty. A true and correct copy of Attorney Lafferty's affidavit and exhibits thereto is included in the exhibit list and marked as Exhibit 15. At the time the Pennsylvania State Police downloaded Bree's cell phone, she was 16 years old and in 10th grade. Defendant's counsel in this case filed a motion to obtain the text message downloaded from the victim's cell phone in 2010 criminal case directly from the district attorney's office. A court order allowing for their release was obtained, and the text messages were produced by the DA's office to defendants marked ST-2790 to ST-2905. These messages were produced to plaintiff in discovery. The text messages are attached to ADA, Patricia Lafferty's affidavit as Exhibit B. See Exhibit 15. Plaintiff's counsel has not recorded depositions of anyone from the DA's office, the Taylor Borough Police Department, or the Pennsylvania State Police. Plaintiff has not conducted any discovery aimed at challenging the authenticity of the text messages secured by the DA's office. Plaintiff has not even recorded Bree's deposition. They haven't deposed Bree. They haven't. Phil, you know how Phil keeps saying these text messages are going to be thrown out in court? These text messages are bullshit. We got the evidence. He hasn't submitted any of it. And it's closed. Discovery's closed. He hasn't even challenged. He hasn't even challenged these text messages at all. He's been lying the whole fucking time. In recent years, the Pennsylvania Superior Court has issued a series of opinions pertaining to authentication of text messages. These decisions demonstrate that multiple factors help establish authentication of text messages, including 1, direct or circumstantial evidence as to the identity of who authored the text sent. 2, testimony from the persons who sent or received the text messages. Recognize recipient or sender testimony as direct evidence of authenticity. 3, contextual clues in the text concerning the crime charged tending to reveal the sender's identity. 4, the defendant's possession of the cell phone containing the text messages. 5, the defendant's admission to owning a cell phone. 6, time and date of the messages sent in relation to the crime charged. 7, evidence establishing a distinct characteristic of the messages. 8, no evidence of a third party having access to cell phones. That's all of them. Godlewski waived his right to have a preliminary hearing in his 2010 criminal case on September 27, 2010. Judge Guerrero conducted a pretrial conference on November 12, 2010. At that conference, Godlewski and the prosecutor agreed to a plea bargain whereby Godlewski would plead guilty to the corruption charge under 18 PA CSA 6301A1, and all the other charges would be dismissed. At the time Godlewski was charged, and when he signed the guilty plea colloquy, read, at the time that Godlewski was charged, and when he signed the guilty plea colloquy, 6301, remember I told you that the law changed? 6301 read this: whoever being of the age of 18 years and upwards, by the act, corrupts or tends to corrupt the morals of any minors less than 18 years of age, or who aids, abets, entices, and encourages any such minor in the commission of any crime, or who knowingly assists or encourages such minor in violating his or her parole or any other order, commits a misdemeanor of the first degree. Any person who knowingly aids, abets, entices, encourages a minor younger than 18 years to commit truancy commits a summary offense. Any person who violates this paragraph within 1 year of the day of the first conviction under this section commits misdemeanor of the third degree. A conviction under this paragraph shall not, however, constitute a prohibition under Section 6105 relating to persons not to possess, use, manufacture, control, sell, or transfer a firearm. Godlewski and the prosecutor agreed upon the sentence of 3 months home confinement to 23 months. Godlewski's counsel reserved the right to withdraw the guilty plea if the court did not accept the recommended sentencing. Godlewski's guilty plea colloquy signed November 12, 2010 states, do you understand that pleading guilty, you are admitting that you did the things you are charged with, and that if you plead not guilty, the Commonwealth cannot force you to take the stand and either admit or deny that you did the things you were charged with? Yes. Godlewski admitted he did the things he was charged with. He was charged with corruption of a minor for having sexual intercourse with a minor victim. The guilty plea colloquy was signed by Godlewski and his attorney, and information was filed by the district attorney charging Godlewski with corruption of a minor for repeatedly having inappropriate text messages in contact with a minor. Judge Guerrero advised the parties the negotiated sentencing was too light and Godlewski would be getting off too easy for the magnitude of his crimes. In light of the judge's plan to hound down a stiffer sentence, the guilty plea was withdrawn by Godlewski. So this is where we get this withdrawn guilty plea. Now, he says when I asked him about this, like, you pled guilty once, he's like, oh, that just has to do with different cases. No, it was because all he wanted was house arrest, and the judge was going to fucking put him in jail, if not prison. So they withdrew. Case proceeded on all 8 counts. A preliminary hearing was scheduled, but the problem is that gave him more time to convince Bree, right? A preliminary hearing was scheduled for the date In July 2011, at the preliminary hearing, the minor victim asserted her Fifth Amendment right to remain silent because Godlewski begged her to do so and even threatened suicide, Exhibit 7. Bree just wanted the case to be over with, Exhibit 7. The parties took a break from the preliminary hearing. Even though Bree stopped cooperating with the prosecutor refused to drop the case since she knew Godlewski just wore the victim down and she had his text message proving he had sex with the victim. The parties reactivated the plea bargain discussion. The same plea deal and guilty plea colloquy was brought back to Judge Garullo. This time, Judge Garullo accepted the negotiated sentence. All the charges except the corruption charge were null prost on July 11, 2011, which is the same day Godlewski was sentenced on the corruption charge. A true and correct copy, Exhibit 19. Evidence of Godlewski's sexual relationship with the minor victim. Bree has executed an affidavit stating that she was in a sexual relationship with Godlewski when she was 15 and he was 25. Also, Bree testified in court about their sexual relationship on February 6, 2023. She was cross-examined by plaintiff's counsel. Plaintiff testified in his deposition, "I can't prove that something didn't happen in this case. Let me tell you about a watermelon, Tim." Godlewski also testified, "I can't prove a negative and I don't have to prove anything," when he was questioned about sex with a minor. Plaintiff concedes his corruption charge was for having sex with a minor. Godlewski admits that according to his guilty plea colloquy, he admits to doing the things that he was charged with. Since it is plaintiff's burden to prove falsity under HEPS, the court could end this case right here. If the court wants to dig deeper, there is substantial evidence proving Godlewski was in a sexual relationship with Bree when she was a minor. Dory Gallagher, referred to herein as Dory, started living with Godlewski in 2006, 2007, and they became engaged in 2007. Exhibit 20. Dory and Godlewski were married in 2012. Exhibit 20. Before Godlewski pled guilty to corrupting Bree in 2011, Bree came to Dory's place of work to tell her about her sexual relationship with Godlewski. Exhibit 20. Dory called her a liar. Exhibit 20. A couple of years ago, Dory apologized to Bree for not believing her. Exhibit 20. Godlewski never showed Dory his text messages with Bree. Exhibit 20. So Dory's dumbass never did read the text messages. The whole time they were together, she never saw them. Before Godlewski was arrested, Dory sent Bree messages on Facebook Messenger and asked her what was going on between her and Godlewski. Bree responded to her stating they were just friends. Before sending Bree this message, Dory reviewed her cell phone bill and saw entries of 500 text messages but no content between Godlewski and Bree in just 2 days. The deposition, Exhibit 21. Dory found Bree listed under a fake name in Godlewski's cell phone. The phone bill also shows they were having long phone conversations. Even though she asked to see his text messages, Godlewski would not show them to her. He was deleting the messages. Sierra O'Malley was Bree's best friend in high school. Bree first met Godlewski at a car wash fundraiser in the summer before Bree entered 9th grade. Bree was 14 years old. Godlewski admits he invited Bree to the car wash fundraiser. Sierra saw Bree and Godlewski together about 20 times when Bree was in 9th and 10th grade. Sierra and her friends would secretly follow Godlewski and Bree after he picked her up in his car. Godlewski would take Bree into houses. This happened maybe 10 times. Bree's friends were coming down on Bree in 10th grade about Godlewski. They were at a sleepover and they took Bree's phone to her mother. So this wasn't just like if somebody found out. Like her friends are like, this is fucked up. Like this shouldn't be happening. We've got to tell on you secretly. So they took her phone at a sleepover and gave it to her mom. And it's like, look, you got to see this. Bree has also signed an affidavit swearing the text messages marked SC 2790-2905 attached to her second affidavit are her text message with Godlewski. Godlewski admits his cell phone number was 570-780-4567 in 2010. All the text messages shown on Exhibit 14 match up to the exact times on Linda, Bree's mom's phone bill. I told you I had matched these. I got them both. I've got all the messages and I've got the phone bill. A true and correct copy of the phone bill affidavit, Exhibit 23. Godlewski has no evidence challenging the authenticity of the phone bills. Exhibit 24. Linda's phone bill records show the times of all text messages on Bree's phone in Eastern Time. The spreadsheet of text messages downloaded by Pennsylvania State Police shows all text messages in Greenwich Mean Time, GMT, on a 24-hour clock. Certain of Godlewski's texts provide contextual clues which reveal the sender's identity to be Godlewski. For example, on ST 2811, line 413, the sender tells Bree on February 28, 2010 at 11:07, I have an open house in Music at 12. Just getting stuff ready. The open house listing from the Sunday Times on February 28, 2010 shows that Phil Godlewski was indeed hosting an open house at 110 Springbrook Road, Music, on February 28, 2010 at 12 p.m. True and correct copy. Exhibit 14, page ST 2863 discusses the sender buying Dory and Infinity. Godlewski admits he did in fact buy his fiancée Dory and Infinity in 2009, 2010. In Exhibit 14, page ST 2816, the sender wrote, I'm scared to buy you things since the earrings. Both Bree and her mother testified in court on February 6, 2023 that Godlewski gave Bree diamond earrings when Bree was in 9th grade the year before this text message. Exhibit 14, page 2838, the sender from 570-780-4567 wrote, she went to the fucking school with the earrings and phone records and got me fired. Yeah, I'm pretty familiar with your mom. Linda did in fact go to the school. Godlewski's live-in fiance at the time, Dory, testified that the high school made Godlewski to step down as baseball coach because Bree's mother wrote a letter to the school. Exhibit 14, page ST 2844, the sender of 570-780-4567 wrote, it was January 8th. I just looked, and that was 2 days before we started talking. I know because Jan 8th is my mom's birthday, and we started after that. Marie Godlewski is Phil's mother, and she testified that January 8th is indeed her birthday. Uh-oh, Phil. Oh, no, Phil. Plaintiff made a post on social media on May 9th, 2023. After my team disproved the text messages' authenticity, my charges were dismissed, all but one, and my guilty plea has nothing to do with sexual contact, sexual conversations, or anything to do with sex whatsoever. He also posted on the same day, the text message recently released between Phil and Bree were not sent by me. I will prove this beyond the shadow of a doubt in court where it needs to be proven, not on Telegram. Plaintiff must now come forward with this substantial evidence in order to prove the text messages are fake. Plaintiff was served with detailed interrogatories, specifically numbers 1 through 4 and 17 through 22, requesting all his evidence that the 2010 text messages are not authentic. His response shows how weak his position is on the issue. He has no evidence other than his denial. Godlewski has not performed any discovery aimed at challenging the authenticity of the 2010 text messages. The court should reject Godlewski's deny defense. He has the burden to prove falsity, and he has not met this burden. Damn, Phil. God damn. You're getting ate up, bro. Godlewski's testimony about why he pled guilty to the corruption charge. Godlewski intends his guilty plea had nothing to do with him having sex with a minor. When asked how he corrupted this minor, what he said, but if you're pleading to corrupting someone's morals, you're admitting you did something wrong. Yes. Okay. When did you do something wrong against Bree? Again, I believe the entire conversations from the very beginning to to the time that I was arrested were completely inappropriate and completely corrupting of her morals. I should not have talked to her at all. I should have referred her to a guidance counselor, a psychiatrist, or I should have backed away from the situation. The very fact that I didn't back away from the situation and I inserted myself as that person was, in my mind, fits the definition of corruption. If you read the definition, that's what I did. That's not included in the law at all. It's fucking sex, committing a crime, violating parole, violating court order. Can you give me just one example of a statement you made to Bree that morally corrupted her? Objection! Please. Asked and answered. You can answer it again. A specific statement? Something as simple as, everything's going to be okay, Bree? I don't know if everything's going to be okay. I'm not qualified to say that it is. I could have been leading her down a path of hope. I shouldn't have done that. Anything else you can think of? I'm sure I said dozens of things like that. I'm not even saying I said that specifically. Here's a question. If Phil claims that he did text her this whole time and that he texted her about, like, everything's going to be okay, I'm your guidance counselor, I'll be your psychiatrist, I'm going to get you. Where are those text messages? Why don't those exist? Why don't any of those text? All the only text messages we get are the sex ones. That's weird. I would say under these circumstances, but something like that are things that I would have said to Brie at the time, just the consoling type conversations. So you're under oath, and it's your testimony in this case that something like that caused you to plead guilty to a misdemeanor crime that could have put you in jail for 5 years. Objection. You can answer. Again, that's not what I said. You said that just now. What I said was the entire nature of my conversations with Bree, in my opinion, were fitting of the definition of corruption of minors. I didn't say, you just said that my specific statement that I gave you as an example of something that I may not have even said, you said that that statement is why I pled guilty to corruption of minors. That's not true. Oh, no. Well, I just want to know what statement it was that caused you to plead guilty to the corruption of minors. Objection. I don't know exactly the statements that I made to Bree 14 years ago. I'm telling you what I think I would have said to Bree in this particular situation. We had hundreds of text messages with each other on this topic. Isn't it weird that he says we have hundreds of text messages and none of them exist except for the ones where they're fucking? Even if these vindictive 15-year-old bitches were trying to frame my hashtag same team friend Phil, where are the good text messages where he's like, it's going to be all right. Everything's okay. We're going to get you a counselor. We're going to get you straightened out. I miss your boyfriend too. Where are those at? Weird. We had hundreds of text messages with each other on this topic. I was trying to console her. I was trying to make her feel better. I was trying to get her to not commit suicide. So you would say stuff on an encouraging level to a person that is about to commit suicide. You would say things like those. So that's what I think I said. Specifically, did I say that? I don't recall. I wish I still had the messages because we wouldn't be here today. No, you'd be in fucking prison probably. So you were trying to console her because you were afraid she was going to commit suicide. After the first yes. Not originally, but yes. Godlewski's testimony is devoid of any details. He does not describe anything of a corrupting nature. Also, he mentions suicide in his testimony above. At the hearing on February 6, 2023, Godlewski testified Bree was suicidal due to her boyfriend, Joe Strzok, committing suicide, and he was trying to console her. In his deposition on July 25th, 2023, Godlewski testified Bree was threatening suicide not because of Joe Strzok's death, but rather because Godlewski was trying to break off his relationship with her. He just cannot keep his story straight. He just cannot keep his story straight. Defendant served interrogatories set 1 on plaintiffs on July 9th, 2021. Interrogatory no. Number 27 asks, why did you plead guilty to corrupting a minor in 2011? This interrogatory is objected to because it intrudes upon attorney-client privilege. This response is included in exhibit list, marked as Exhibit 29. Defense counsel then wrote to plaintiff's counsel complaining about improper objection. Plaintiff's counsel then served a verified supplemental answer to the interrogatory on December 9, 2021. The details are these. Plaintiff's best childhood friend, Joe, was dating the victim. He was 21, she was 16. They were having a sexual relationship. Plaintiff did not know this at the time, but apparently there was a threat to expose Joe. As a result, he committed suicide. The relationship between plaintiff and the victim was only with respect to discussion regarding Joe and his suicide. This is probably why victim pleaded the Fifth Amendment when asked any questions regarding this case. Plaintiff was 25 and all of this happened. Plaintiff and Joe were not friends. They were 4 years apart in school and over 4 years apart age-wise. Joe's stepmother never knew Godlewski or even heard of his name. Godlewski did a social media interview on November 26, 2021, 6 months after commencing this lawsuit, in which he discussed his relationship with a minor victim. Godlewski's story in the interview is full of lies. He claimed he and Joe were good friends. They were in kindergarten together. They're 4 years apart. They were in kindergarten together and attended all the same classes, but parted ways for college. Joe Strzok had a great family. His parents were not divorced. He said he would go over to Joe Strzok's home for dinner and exchange Christmas presents. We graduated together, he even states. Bree was actually consoling me due to the death of Joe. The statement is particularly sickening and shows how depraved Godlewski truly is. Godlewski did not realize defense counsel would get the Riverside High School yearbook showing Strzok graduated in 2006 and Godlewski graduated in 2002. Weird. When challenged at his deposition, he said, I'm aware of some embellishing. I'm aware of some embellishing. In the November 26, 2021, this is what we want to see. His second deposition. We haven't read that deposition yet. The second time he was deposed. Godlewski admitted Strzok was 4 years younger than him, and he didn't go to kindergarten with him. So when he was confronted about this, why did you say you had all the same classes? You went to kindergarten together. He's like, I meant we went to the same schools and probably had the same teachers if none of them retired or, got fired or anything. He admits they did not graduate together. Strzok wasn't in high school when he graduated. Incredibly, Godlewski testified that what he was really trying to say on November 26, 2021 was that he and Strzok had the same teachers in the school district. One can easily see Godlewski was lying and didn't know Joe Strzok at all. Strzok's parents were divorced many years before Joe Strzok died, and his biological mother lived in California. Phil didn't know that. So this is why they were asking about the relationship Strzok had with his family, is Phil didn't know that they had been divorced years before, and his mom lived in California. A copy of Joe Strzok's obituary is included. Godlewski made up a story about Joe Strzok being his best childhood friend to give him an excuse for being in communication with the minor victim. Godlewski never mentioned the name Joe Strzok to Dory. Sierra O'Malley knew Joe Strzok. He was not friends with Godlewski. Godlewski pled guilty to the corruption charge because it was a good deal for him, and the prosecutor had a multitude of text messages between him and the minor victim proving they were having sex. The 2010 text messages leave no doubt Godlewski was having sex with a minor. Below are some of the texts Godlewski sent to Bree in 2010 when he was 26 and she was 16. So I'm like the boy you use for sex and hate every other day of the week now. I wanted you so bad because of the last few days. I disagree. I think she'll still see me as a 25-year-old that fucked her 15-year-old daughter and lied to her about it. Talking about Bree's mom. I'm going to fuck you so hard you're probably split in half. Not with that hate boner, you're not. It just disappears. Great insults, no rationale, just insults. I'm sorry if I don't want to hurt you, and as good as our sex might be, it fails in comparison to my love for you. I love you so fucking much that I've been in tears since 11 this morning. I literally can have sex with you for an entire day. Like, if we had the while not tonight, we would have just kept going. Aw, we had sex in mom's bed. I'm in shock and awe. I never had sex like that before. What happened yesterday? Was I dreaming? I don't understand. I'm frazzled. You're beautiful, and I think you're nuts. I wouldn't alter your appearance in any way, even if I could. And you give incredible head, okay? A 26-year-old man to a 16-year-old girl. I'll leave my house to talk to you. Go home late. Let Dory home for hours while... left Dory at home for hours while we have sex, and I only give you 5%, you're retarded. Godlewski denies that these are his text messages. He admits the following texts of 2021 are true and authentic text messages, a true and correct copy of plaintiff's response to defendant's request for admissions. Exhibit 34. Between he and the minor victim. Yo, want to go to Oklahoma? Bree, this is like our 2010 dream. Phil, I suppose it is. Bree, 4 nights in a beautiful hotel, except... out of state and no one bothering you so you could actually relax and just chill. And me being 27, looking and feeling better than ever about to start my career. So we'll see if you can still suck dick. Excuse me? I feel like this is our 2010 dream. We'll see if you could still suck dick. Uh-oh. Exhibit 35. Phil's messages for 2021 sound like the sender's messages from Phil's phone in November, phone number in 2010. Same crude, misogynistic person. The conversation is above is clearly related to the 2010 time frame by the use of the word still, and Godlewski's response discusses oral sex. Damn it, Phil. God damn it. You let one slip out, buddy. You were this close. You were this close. Godlewski made false statements under oath in this case about whether I've been dying to fucking read these. I've heard about them. I've heard rumors about them. I've heard people talk about. I've been dying to fucking read this. Godlewski testified he never had sex with Bree when she was a minor. However, Godlewski has changed his story about his sex with Bree 3 times during the lawsuit. First, Godlewski's verified answer to interrogatory 7, set 4, made on November 18th, 2022, was as follows. Did you have sex or a sexual relationship with Bree at any time? No. If yes, when did you have sexual relationship with her, and how long did the sexual relationship last? N.A. G. Plaintiff's response to interrogatory set 4 is included, Exhibit 36. Later in the case, after Bree executed an affidavit and produced her 2021-2022 text messages with Godlewski that discussed their past sexual experiences, Godlewski changed his story. At the February 6, 2023 court hearing, Godlewski testified he began having a sexual relationship with Bree in 2013, 2014, or 2015, and certainly from 2015 to 2016. He married Dory in 2012, and she gave birth to their children in 2015 and 2017. At his deposition on July 25th, 2023, Godlewski testified the sexual relationship with the victim definitely began in 2017, that being his third version. Plaintiff further testified that the victim was a lunatic, and he knew that as early as 2008 when he began talking to her. At Godlewski's deposition on July 25th, 2023, he testified as follows. Why did you have sex with Bree in 2017 when you're married and you thought she was a lunatic that ruined your life in 2010? I was in a very bad mental place in 2017. I had just cheated on my wife with Miranda. That's the first time I ever cheated on my wife, and probably the first time I've cheated on any partner, maybe ever. I felt as though my marriage was, I was losing my marriage. It's probably from you fucking other bitches, dude. I tried very hard to gain it back by fucking Miranda. And every attempt that I made in trying to save the marriage was thwarted with aggressiveness by my ex-wife, Dory. She just couldn't get over me fucking everybody else. So probably, I would say out of frustration, sadness, aggravation, and fear of loss is why I started having sex with different women. I used sex at the time, I believe, as a crutch. As a crutch. It was a sex crutch. Goodness gracious. Those hit them with the old sex crutch. No. Did you reach out to Bree to have sex with her? No. I believe Bree reached out to me because she had heard Dory was leaving me. And around that time that Dory decided to leave, I was, other than trying unsuccessfully to get Dory to come back, I was influenced by alcohol quite a bit. So I made some very poor decisions. And one of them was engaging with Bree, the lunatic. Why did it happen repeatedly with Bree? Why did you repeatedly have sex with her? It was good sex. Were you using her for sex? Yes. Well, not just for sex. I wouldn't say using her for sex, no. So I'm going to say no to that if I can correct it. I was using it as medicine for loss. I was really messed up then, Tim. And how did you break it off with Bree when you were having sex with her in 2017? There's nothing to break off. They were casual encounters that I think we were both probably under the influence of alcohol. Me for certain, and her probably. From what seemed to me, other drugs as well. But there was nothing to break off. It wasn't a full-blown relationship, so to speak of, where you have to have a conversation and break up with the other party. It was just, it sizzled. What if, God damn it, I about slipped up on one that'd get me banned on Twitch. Went down to nothing. And you still thought she was a lunatic? To this day, I think Bree is, I guess we would have to define lunatic, but I think Bree, based on her actions in particular to this case and up until recently with her affidavit, I think that Bree is totally mentally ill. And that's remained consistent throughout the entire time you've known her? Pretty much. It sizzled. It sizzled. Godlewski has told so many lies, the court should remember Godlewski's mantra. I have to deny, deny, deny. Damn it, Phil. You let another one slip. I think that slipped right past you. Got to play defense, Phil. His response to interrogatory 33, set 1, dated August 20th, 2021, was as follows. Do you have any letters, emails, text messages to or from the 15-year-old girl? None. Plaintiff's response to request for production of said documents incorrectly numbered as 19 on plaintiff's response dated August 20th, 2021, stated, any documents sent to or from the 15-year-old girl referred to in the article attached to your complaint? None. On August 22nd, 2022, plaintiff served his verified response to the defendant's proof of documents, production of documents, answered number 7 as follows. Produce any text message between Phil Godlewski and Bree during between 1/1/2008 through present date. Plaintiff does not have any. On November 2nd, 2022, Bree consented to have her cell phone downloaded, and she provided her 2 cell phones to a forensic technician to copy all of her instant messages, text messages, SMS, with Godlewski on her new cell phone and her old one. The technician was able to download 1,235 instant messages between plaintiff and Bree from March 31st, 2021 to May 11th, 2022, and 151 instant messages from May 28th, 2022 to September 9th, 2022. Dennis then filed a motion for sanctions against Phil due to his failure to produce the text messages with Bree, most of which occurred while the lawsuit was pending. And he already knew he had to preserve all these documents. Most of these occurred after he had filed, and he knew he had to preserve these documents. Plaintiff has already admitted these are his authentic text messages. The court held a hearing on defendant's motion for sanctions on February 6, 2023. At the hearing, plaintiff testified he had no documents concerning communications between himself and Bree from 2008 to present. He hid his text messages from being discovered by defense counsel because they are damaging. Godlewski tried to bribe. Plaintiff filed this lawsuit on May 27, 2021. Godlewski and Bree exchanged the following text messages 1 year after the lawsuit was filed. 5/28/2022. Okay, kid. If you change your mind and want to hang out, let me know. Why, isn't it even creepier that he had this relationship with her when she was 15 and then he calls her kid now that he's fucking 40? If you change your mind and want to hang out, let me know. Lots of stuff has been going on. I wanted to try to insulate you as much as possible, but I get the feeling you already know, so I'll back off. I'll be here if you want to meet up and chat. It's Bree. I think it might be fair to say there's a very, very large, very, very unique financial opportunity that exists in front of you. Lol. The type of opportunity that happens to hardly anyone. Are you trying to recruit me for the silver thing? No. We really need to meet and chat. I can't talk about this through text or over the phone. Okay, well, that makes me feel better. When you're ready, I have an opportunity that involves the both of us, but it won't work with just one of us. I don't know which way to go until I speak to you. So remember me for when you feel better and we'll talk. I know I've been wanting to talk to you about almost the same thing, weirdly enough. I've been the one who has wanted to square things up with you that has nothing to do with romance or Amanda that would save both of our reputations, but I didn't plan on talking to you about anything until my school stuff was over. I got my diploma and my job was written in stone. I'm sure Amanda told you a little bit, which is okay because it wasn't a secret, at least not from you. We got our lives dragged through the mud for years together, and it has affected us both professionally to the point where my internship was based on my ethics and morals, but I passed with flying colors. And pretty sure I may have gotten an almost full ride to get my MSL in data and privacy law. So yeah, I'm okay. And I know you've had to defend yourself for years, which a lot hasn't had to do with me, but I don't like that people make it seem like you were some creep or I was some home-wrecking little tramp, and I think us having each other's backs in some regards benefits both of us. I agree, but it's a very delicate situation, and unless it's handled properly by both of us, we stand to benefit nothing, absolutely nothing. And there is a financial windfall here if handled properly. That's all I can really say through text. I don't trust those motherfuckers, and I'm literally foaming at the mouth to take them down once and for all. You're a good person, Bree. You don't deserve anything that's happened to you since we met all those years ago, and I think it's time to set the record straight and shove our collective middle fingers directly up their fucking assholes. That almost sounds like his fucking sexy talk. No, I know it's like most delicate situation. Aside from any of your extra troubles or my extra troubles, what happened between us follows us around the most, and nothing between us was ever bad. Even when I heard things about you and Miranda or you being an asshole, I mean, my first thought was that Phil has never even so much as raised his voice at me and said anything nasty to me ever. Through everything and all of it, you've never been mean to me. You had to defend yourself because you had no other choice. I mean, I'm going to be 29 and you're like 37. I know this sounds crazy, but there's examples of cases where, let's say, the girl was older, like 18 or 19, and the boy was 16. That age difference is nothing. But if the girl had a very high IQ and the boy was significantly lower, then that could be considered statutory because it shows, despite the age, she was clearly taking advantage. That's the IQ defense. My friends and my mother blew this wide open after my first love hung himself when I was 16. And the older I got, the more I learned from school and this field. It really bothers me. But we have both been dealt our fair share of nonsense throughout the years and trying to get our lives in order. But I say all the time, I've told my family and friends and professors who basically took me under their wings that aside from any kind of trouble either of us have been in, you were never mean to me, never took advantage of me. It wasn't even about sex. I have been mentally 20 since I was a teenager, but literally my entire life, whenever I have needed you, you have picked up the phone. We were never enemies and we were never intentionally trying to hurt each other. But yes, this is very delicate. And I believe being allies would shut up a lot of people. And Phil says, well, let's meet when you're ready, sooner rather than later. I miss you anyways. Bree says, like I answered you at 9-something and was like, whoops, Lamal. Phil, listen, my friend, things are getting very nasty with Scranton Times. I think you should know what's going on. I'd like to talk to you in person. I don't want you to be blindsided by any of this. I have your back, Bree. You should see what they are trying to do to me. It's absolutely awful. Bree, I wasn't not answering. I have weird stuff going on right now. To laugh out loud. I was going up till 4 a.m. doing work, so I fell asleep without an alarm, and here I am. I'm going to try not to be grouchy, because I am, but you don't have my back. You don't have my back. I have yours. This has nothing to do with me, Phil. I'm sorry a reporter politically dragged you because of something that happened to us 12 years ago. I read the entire article recently, and it was definitely quite excessive and very unnecessary to throw that in about me and you. It was basically an entire article just dragging you and your life and then casually throwing in, oh, he slept with a 15-year-old girl, blah, 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 real estate stuff. It was dumb. It was just a shot at you, and by association, I am involved. But the thing is, I never wanted it to happen. I'm going to be 29, though, and full-blown in this field now, and still blame my mom and my friends for what happened, and no one can ever reason with me otherwise. But the problem for me is that I haven't been able to speak up then, which is my choice, or now to you or to anyone who can end this, because the truth is, like I told my mom the other day, I don't remember if I was 15 or 16 when we slept together. I really don't. But I do know I've always been 10 plus years past my age. You weren't my coach. You weren't an authority figure of mine. You didn't hurt me. And what happened back then, the arrest and etc., was just the beginning of what would continue to be us sleeping together on and off. And whether we were fucking or talking or whatever, we were always on good terms. I've never genuinely hated you or you me.
Got a small dick, but wait till it get hard. She gonna be like, damn,
10 six-packs from Bevy G. You win the award for the best dramatic doc rating of all time. Thank you very much. I appreciate the donation. But my truth and my story and the way I feel and the way we could end this is complete opposite of everything you've been saying and building off of since it happened. Personally, to me, I think the Times is annoying for bringing it up, and it also pissed me off. I think people that still talk about it are annoying. The fact you chose to start doing political stuff has nothing to do with me, but when those people specifically come at you and your only defense that you feel like you really have because of all those years ago is to say I was some sick and crazy love-struck obsessed teenager, and because you were so loyal to Dory and it was so wrong, but yet Joe Strzok was your best friend too. Yeah. So this is what I was telling you guys. This is what pissed her off enough to finally stand up against Phil. Was every time it came up, he's like, this stupid bitch, she tried to ruin my life. She was like, I love Dory so much, and that was my best friend. She was tired of that shit. You were there for me, and because I was so broken and lost and sad and love struck, I told on you and tried to get you arrested because I was just so in love. You've been telling that story for 12 years as I've had to sit back and never speak my side, never even think about it. And the only reason that gets to happen is because I got up on the stand as a 16-year-old and threw away the prosecution's entire case in front of a courtroom and my family and the entire town because I loved you and I never wanted it to happen either. My mom has tried telling me that some lawyer for the Times asked her to come in and talk. You were always telling me you are ready to come out swinging and fight with them and go against them. Well, I'm against all of it. My mom is a huge reason this happened in the first place, and the fact that she has the audacity to even think for a second about doing this again when I'm going into this field as an adult now because of what happened then. I screamed my lungs out at her probably last month. Then I got to hear from you asking you to help me when you go on YouTube live for the last however many years and tell thousands and thousands of people that I'm a liar and it never happened and we have no affiliation. And the Times chasing you and whatever beef you have with them and them trying to drag this back out again is so fucking annoying. The side you tell to the public is not the truth. And I'm not saying that in a mean way. I understand you basically had no other choice, especially at the time. My mother has absolutely no fucking idea what happened between us, and the Times has absolutely no idea what happened between us. Phil, I don't see you as my public enemy or some guy who hurt me or ruined my life or any of that. I see you as my ex-boyfriend because that's what you are to me. What happened during the arrest is just what went public and made you look bad. But all you've done is battle those claims, and it was my fault to never speak up on my side. I pled the fifth then, and basically I've always throughout the rest of my life because I have been cleaning up the mess that made and the mess that followed me with Jay and drugs and hell. I mean, from 2020 to 2024, I was broken and depressed. Zombie because of all the shit that happened between us and between everything. I finally got my shit together and straightened things out internally and externally, and then boom, we link up as adults and fly across the country together, and you pulled that shit with Amanda. And still, I have never said one nasty thing about you publicly or anything that could ever hurt you. And I know the only reason that you have had to do the same to me is because of something that happened 12 years ago. But we didn't just sleep together when I was 16. It was 17, 18, 19, 20, 21, 22. Phil, we have always been in each other's lives and never hated each other. I've just never said a word or argued about it or cared because the public story you tell is true and the story the Times published then and now isn't true. It's all untrue. There was no scandal in my eyes. You weren't some gross old man. You were never mean to me, ever. I hear shit about Dory and all these ex-girlfriends and shit that happened and my jaws drop. Yeah, sure, I think you lie, but we went through the biggest thing ever, and you have never raised your voice at me, and we have basically always been friends, sleeping together or not sleeping together. We've always been cool. But to me, and to you too, it wasn't a scandal. I was going through the worst time of my life, the most traumatic thing I've ever experienced still, and you weren't some scandal to me or some cool older guy I thought was cool, so you weren't some creepy coach exercising authority and preying on teenagers. We genuinely cared about each other, and you were my boyfriend, except you were engaged. We didn't break up. We were legally pulled apart before we ever figured out anything out, and neither of us had a say. Well, I did, and I chose to protect you, and it's because you never hurt me, ever. I mean, I don't even know if you remember this, but it was years after everything happened, and I was with Jay still, and in a really bad place, and you and I met up in a hotel room, and because I didn't look good and wasn't myself and was telling you about Jay, you didn't even touch me. I don't even think we kissed. We sat on a bed, and you were almost in tears, begging me to please get my shit together and please get away from Jay. Neither of us were in trouble. I was in my early 20s at that point, but that is my point. This goes so much deeper than what it is made out to be. I mean, we genuinely loved each other back then, now, and probably always. It doesn't matter how you feel or what you want. You only care about the story you tell and your public image, and you much rather have people write articles about you and drag you and lie about you and make you look like some sicko instead of ever bending or changing your public story that you told all those years ago, even if it's still making you look bad. You'd literally rather that than ever remotely slightly go back on anything you've ever said. I'm legit in school for what I'm in school for, to protect myself against this shit and boring, sad, lonely people from Scranton, PA who have nothing better to do than to talk about a guy and a girl having sex literally almost 15 years ago. I mean, it's so fucking pathetic and obnoxious to me now. Phil, if we can come to an amicable agreement that has nothing to do with my schooling or you thinking whatever, or my family, or Chris Kelly, or any of it, if you and I can come to an amicable agreement that you stop dragging me publicly and defending yourself, and with defending yourself comes making me look like a fucking asshole, If you can agree to stop letting those bored-ass lowlifes get under your skin and get a rise out of you, and shut your big opinionated mouth for 10 minutes, and stop giving people ammo to shoot back at you, I can promise and will make sure that when all of this stops, that you never have a reason to defend yourself ever again. Because I will make sure that the Times leaves you alone, leaves me alone, my family alone, and my family and friends leaves you the fuck alone. What do you think I've been doing, huh? Listen, our personal shit aside, I don't care, and I know you don't either, but publicly we're still tied, and people are still bored and jerking off to our sex life from 15 years ago, and it's honestly so weird and overbearing and fucking obnoxious to me, and I can't hear about it anymore. No Amanda, no political tube, no lives, nothing. You and I have to come to some kind of terms, and all I ever wanted from you is to please stop calling me a liar and making me look like an asshole. It's not true, and all I've ever done is try to protect myself and you by association. How's that? So, honestly, if we wouldn't have kept pressuring Phil about him and his charges and the minor, she personally believes that Phil didn't take advantage of her. It doesn't really matter because at the time she was 15, so it's still illegal. Whether she believes she wasn't taking it, that doesn't matter. And I respect her belief. She believes whatever she wants. But if we wouldn't have kept pressuring Phil and putting out videos and calling him out and calling him what he fucking is over and over, and he wouldn't have had to keep defending himself and calling her crazy and a dumb bitch and I love my wife and she was a psycho, this feud never would have come here. Let's meet and talk. I think we're mostly on the same page. Irregardless, we need to meet and speak. You need to know some stuff that you aren't aware of. Irregardless, looks like we both smack dab in the middle of quite the legal tornado. Not really. We have to talk in person. Listen, I already told you, aside from your beef and tugging of the heartstrings argument you have with Chris Kelly, or any prior trouble aside from me, that is irregardless. But I will make sure that no one ever calls you a pedophile again, and our public beef can be squashed, and Linda leaves us the fuck alone, her mom. It's not that, Bree. It's more than that. We have to meet because there's stuff you don't know. Plaintiff has admitted these texts obtained from the download of Bree's phone are his true and authentic text messages with Bree. In response to Bree's long text message, Galuski stated, "We're mostly on the same page." Bree's long message stated they were having sex when she was 15 or 16 years of age. There is no denial from Galuski in his response. After they continued having sex the whole time, by the way. After Godlewski sent Bree these text messages about a financial opportunity, she met Godlewski at her friend Amanda Torini's house. During February 6, 2023 court hearing, Godlewski testified as follows. Okay, did you offer Bree any money at that point in time? Did you offer any financial assistance to Bree at any point in time? How about in the last 2 years? Yes, I have. When was that? At some point last year, Bree was, according to what she told me, struggling to make ends meet with college, and she had a very vigorous schedule in college. She would take a numerous amount of credits per semester, which didn't really leave a lot of time in the day to work. So I believe we discussed, some sort of loan. As I've said before, I've always been, whether it's true or not, I've always felt like I was a brother to Bree. You disgusting motherfucker. And I always felt that it was somehow my responsibility to help her if I could. We've had, obviously, yeah, because she kept you out of fucking prison for 30 years, you disgusting piece of shit. We've had, and I always felt that it was somehow my responsibility to help her if I could. We've had, obviously, some very well-known public episodes with one another, but in the grand scheme of things, we always seem to have each other's back. So when she requested to me, or when she informed me that she was having some financial difficulty, I was the first to say that I could help. In fact, I've done that with dozens of people within the same time frame, both family and non-family. Were all of them lunatics, Phil? Were all of them lunatics, love-sick lunatics who just made shit up? That's weird. Have you threatened to sue Bree because of her giving me this affidavit? Yes. In this testimony, Godlewski claims he's like a brother to Bree, and they always had each other's back. Obviously, she asserted her Fifth Amendment right for him. Godlewski offered her $50,000 if she would say she was 18 when they started having sex. Bree refused to lie under oath for Godlewski. Amanda Torini testified that Godlewski and Bree did meet at her house. Their cell phones were put in her microwave during the meeting. This was done to prevent any type of tapping into their phones or listening. Oh, this idiot. Jesus Christ. This doesn't work, guys. I don't know if this is a movie that everybody's. This doesn't work. A microwave is not a Faraday cage. A microwave does shield a bunch of different frequencies, but it's not the frequency your phone works on, or it'd burn your fucking face off. I've climbed a cell phone tower through a microwave dish one time that was supposed to be off, and it wasn't. And it burnt the piss out of me. Like, by the time I got down, I had fucking blisters all over my body. Like, the most extreme sunburn you could imagine. Like, if your cell phone did that, it would fucking fry your goddamn face. I think it's, somebody said it's in the movie Snowden. It's in the Snowden movie. That's probably why he's obsessed with it. It doesn't work. That doesn't work. It's not the same fucking frequencies that need to be shielded from. Do you think, like, companies try to cut every corner they possibly can, okay? So when they try to cut every corner they possibly can, if they have to shield from this megahertz to this megahertz to make it safe to where it'll get, get fucking approved to be sold, do you think they're going to go above and beyond and shield other frequencies that they don't have to? Of course not. Fucking retards. I think the magnetron in a microwave is like 2.4 gigahertz or something, somewhere around there. That's what it's shielded to protect from. So you don't microwave your face when you're like a little kid. They put their head up against the microwave and watch their food go around. Galuski wanted to talk to Bree about his lawsuit against the Scranton Times. Galuski testified on February 6, 2023. He was only texting Bree about his distrust of the federal government, not the Scranton Times. Galuski wrote to Bree, "It's time to set the record straight and shove our collective middle fingers directly up their fucking assholes." He claims he was not referring to the Scranton Times. It is easy to see he was trying to rig this case by suborning perjury from Bree. That close, Phil. We've got to add them together. You're about that close. You just let a medium one slip through, buddy. Just a medium one. Godlewski lied in his written discovery responses when he wrote that he never gave gifts to Bree. Then he testified on February 6, 2023 in court. He said he gave Bree a tanning package. Who the fuck? This is the biggest goddamn red flag. Imagine you find out that you're 15. You imagine me. I'm a 25-year-old dude that works at the high school. Okay? Imagine your 15-year-old freshman comes home an hour late from school, and you're like, "Where you at? Where you been?" And they're like, "Oh, I was at the tanning bed." And they're like, "How'd you pay for it?" And they're like, "Oh, 25-year-old baseball coach at my high school bought me a tanning package." Yeah, bought me a tanning package. You believe that shit? Imagine. God damn, dude. God damn. And he just testified about, yeah, I bought her a tanning. I think it was a tanning package. Yeah, she said her card wouldn't work. And goddamn, do I love a nice fucking cinnamon body. Jesus Christ. Got Brie a tanning package, an Ed Hardy hat, and maybe a shirt. These gifts were given to Brie in 2008, right after her boyfriend, Joe Strzok, committed suicide. Linda is the mother of Brie. Linda learned her daughter was involved in a relationship with Godlewski when he gave her an expensive pair of earrings. Linda and her husband wrote a letter to the Riverside School District on January 27, 2009. Linda brought the diamond earrings into court on February 6, 2023. Linda would not allow her daughter to wear them. She took the earrings to Zales because they were in a Zales box.
Ray Nike just resubscribed for 19 months. Best damn 19 months. Best damn 19 months.
Thank you. 19 months is a long time. I appreciate that. That's a calm too. She was informed at Zales that the earring cost $2,850. Imagine again, your freshman from high school comes home with some diamond earrings that are more expensive than you're fucking wearing, and they're like, "Where did you get those $3,000 diamond earrings?" You're like, "Baseball coach." You don't play baseball. Yeah, I know. He said he'd take me to practice my swing later. Get the fuck out of here. Linda spoke to Godlewski on the phone about the earrings, and he said he was just trying to be friendly. Linda later went to the police about the relationship, of course. The police interviewed her daughter. Bree was emotional and did not want to talk to the police initially, but she broke down and told them about the sexual relationship. Joseph was the principal. Joseph, what does Phil call Mo? Principal Mo, was the principal at Riverside High School back in 2009. Mr. Mo wrote a memo regarding an unusual phone call he had with Godlewski on January 8, 2009. There's a copy of it. He called Godlewski in the morning of January 8, 2009 because of the rumors going around the school that Godlewski was involved in an inappropriate relationship with Bree. Godlewski denied buying her diamond earrings to Mr. Mo, but admitted to him he gave her a hoagie. Yeah, he did. Like, that's fucked up and that's disgusting, but yeah, he did. Godlewski told Mr. Mo he had not spoken with Bree in weeks. Mr. Mo directed him to have no contact with Bree. Mr. Mo received a letter from Bree's parents dated January 27, 2009. So that was what? 21 days later? 19 days later. The letter stated Godlewski gave the daughter diamond earrings. The letter included the parents' phone records showing 250 text messages between Godlewski and Bree on the day of Mo's morning call with Godlewski. The day his principal calls him. The day his principal calls him and says, hey, are you fucking this girl? And he's like, no. Well, don't talk to her at all. He has 250 text messages with him. By the way, Phil still claims he never worked at the Subway, but he gave her a Subway sandwich at the Subway that he was working at. Both those are true. Joe Strock, S-T-R-O-K. Strock, Joe Strock. They always call him Stork, like stork, but Stork, but it's spelled Strock, so I don't know. The day that the phone call was made with Godlewski did not adhere to Mr. Mo's no contact directive. Plaintiff admits he had sex with Bree a number of times after she turned 18. The fact alone is telling. The preceding sections in the brief prove Godlewski is a liar when it comes to his relationship with Bree. He lied about whether he'd ever had sex with Bree. He lied about whether he ever gave her gifts. He lied about whether he had communications with her after he filed a lawsuit. He lied about his relationship with Joseph Strock. He lied about the financial opportunity he offered to Bree. He lied about all these matters because the truth on those matters tend to show he had sex with Bree when she was a minor. Little bit, Phil. You just missed it that much, dude. That much. We're this close. Plaintiff must prove any false statements in the article were made with actual malice by clear and convincing evidence. New York Times versus Sullivan, the Supreme Court held liable can claim no talismanic immunity from constitutional limitations against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks. The First Amendment guarantees have consistently refused to recognize an exception for any test of truth, whether administered by judges, juries, or administrative officials, and especially one that puts the burden of proving truth on the speaker. Freedoms of expression require breathing space. Recognizing that public figures assume special prominence in the affairs of society, the Supreme Court in Getz observed that two characteristics are particularly relevant to such designation, namely, the ability to rebut the defamatory statements due to greater access to the channels of communication. So a celebrity, if a news article comes out and says something about a celebrity, or anybody says something about a celebrity has a greater propensity to rebuttal because they can talk to more people, right? They can get out to their audience. That's one. Greater access to channels of communication than private individuals. Public officials and public figures usually enjoy significantly greater access to the channels of effective communication, hence have more realistic opportunity to counteract false statements that private individuals normally enjoy. And expose themselves to increased risk of injury. If plaintiff is a public official or public figure and the statements relates to a matter of public concern, then to satisfy First Amendment strictures, the plaintiff must establish that the defendant made a false and defamatory statement with actual malice. That's two. A public official or a public figure must prove actual malice, which is defined as knowledge that the publications were false. So how do you prove actual malice? The person who wrote them, the newspaper reporter or whatever, a news reporter who wrote them, whoever wrote them, has to actually know that they're false and write them anyways, or have a reckless disregard. Like, I don't care if they're false or true or not. I'm not even looking. I just want to say it. Those things. A reckless disregard of whether they were true or false by clear and convincing evidence. The plaintiff must prove by clear and convincing evidence that alleged defamatory statements were false and that appellant newspapers either knew they were false or recklessly disregarded their falsity. Indeed, the actual malice standard is expressly predicated on the need to protect reporting of matters of public concern involving public officials. Actual malice is a fault standard predicated on the need to protect the public discourse under the First Amendment from the chill that might be fostered by less vigilant limitations on defamation actions brought by public officials. So if these rules weren't in place, the actual malice standard wasn't in place, then we wouldn't talk about celebrities because they got money, they got power, and they're sue the fuck out of you. You couldn't even if you thought it was true, you couldn't publish it because you couldn't prove it 100% beyond a doubt, and the public would never know. The stake of the people in public business and the conduct of public officials is so great that neither the defense of truth nor the standard of ordinary care would protect against self-censorship and thus adequately implement First Amendment policies. Neither lies nor false communications serve the ends of the First Amendment, and no one suggests their desirability or further proliferation. But to ensure the ascertainment and publication of truth about public affairs, it is essential that the First Amendment protects some erroneous publications as well as true ones. It is essential that the First Amendment protects errors in publications, erroneous publications, as well as true ones. Because some things you're not going to know beyond 100% shadow of a doubt, no question asked. And the public still needs to know that there's a chance. Supreme Court expanded the substantial burden for proof to include public figures who file defamation actions. The burden of proof imposed is substantial, and as the actual malice standard goes so far as to forbid imposition of liability, even in those instances where the defendant negligently publishes false defamatory statements about a public figure or public official. Indeed, the actual malice standard is this is what fucks Phil right here. He never should have signed the fucking document that, hey, can't find my diplomas, so I'll sign an agreement that I'm a public figure, because you're a fucking retard and you don't know the way the law works. Listen to this. This is from the Supreme Court, okay? The Pennsylvania Supreme Court. The actual malice standard is a rigorous, if not impossible, burden to meet in most circumstances. So Phil's talking about his case like it's a slam dunk, right? They said it. I did do it. We're going to win billions of dollars right now. For what he has to prove it's an actual malice standard, and it's rigorous, if not impossible, burden to meet in most circumstances. You would literally have to have like a text message from Chris Kelly talking to his wife, and his wife's like, "Are you publishing about Phil?" And he's like, "Yeah, it's not true, but fuck that motherfucker. I hate him." Like that's what would win this case. That's what would win this case. The failure to check sources or negligence alone is simply insufficient. So remember when Phil's lawyer was asking Chris Kelly, "What did you check this? What did you check that? What did you check? Did you read the guilty plea colloquy? Did you read this? Did you speak to that person? Did you talk to that?" Failure to check sources or negligence alone is simply insufficient to maintain a cause of action for defamation. Recklessness, generally, and in the context of actual malice, is not easily shown. Rather, to establish that a defendant acted with reckless disregard for the truth, there must be sufficient evidence to permit the conclusion that the defendant, in fact, entertained serious doubts as to the truth of his publication. Moreover, establishment of a defamation claim requires clear and convincing evidence, the highest level of proof for civil claims. The standard requires evidence so clear, direct, weighty, and convincing as to enable the trier of fact to come to a clear conviction without hesitancy of the trust of the precise facts in issue. You're never going to get a jury to get that, to be that convinced on this case. No goddamn way. The judge shouldn't be that convinced. The judge should throw it out. The requirements that the plaintiffs be able to show actual malice by clear and convincing evidence is initially a matter of law. The question whether evidence in the record in a defamation case is sufficient to support a finding of actual malice is initially a question of law. The important role the court serves in determining the threshold issue of actual malice as a matter of law is well documented. This rule is not simply premised on common law tradition, but on the unique character of the interest protected by the actual malice standard. Our profound national commitment to the free exchange of ideas, as enshrined in the First Amendment, demands that the law of libel carve out an area of breathing space so that protected speech is not discouraged. Most fundamentally, the rule is premised on the recognition that judges, as expositors of the Constitution, have a duty to independently decide whether the evidence in the record is sufficient to cross the constitutional threshold that bars the entry of any judgment that is not supported by clear and convincing proof of actual malice. Premised. I said premised earlier. Premised. That is from Tucker, quoting Hart Hanks Communications, Inc. and Conington. He's not going to win this case. There's no goddamn way he's going to win this case. He's sowing more doubt than the fucking defense is. Changing his story, won't submit evidence, hiding shit. Pennsylvania appellate courts have routinely upheld the granting of a summary judgment by trial courts wherever a plaintiff cannot meet its burden of showing facts establishing actual malice. Pennsylvania appellate courts. So basically, judges rule. Right? Judges make rules. They say yes, no, guilty, innocent, whatever. And then, or juries rule, and then that goes to the appellate when it goes to be appealed. And that may go to like the First Circuit or First whatever, might go all the way to Supreme Court. But once it goes past that judge, let's say that judge rules, or any judge rules on this level, at the lowest level, once it goes to the appellate court, the lawyers and judges are responsible for knowing what the way the appellate court ruled. And even though they're independent and can make their own ruling, they are supposed to be influenced by the judges above them, right? If the Supreme Court is overturning this one thing because they say it's free speech, and then it comes up again in your court, you're supposed to know that the Supreme Court overturned that because free speech. Your lawyers should know this too, and that's the traditional ruling on these cases, and that should heavily weigh in your judgment factor when you rule on these cases. Let's see. Pennsylvania appellate courts routinely uphold the granting of summary judgment by trial courts whenever a plaintiff cannot meet its burden of showing facts establishing actual malice. Affirming trial court's entry of summary judgment where plaintiff could not show actual malice by clear and convincing evidence. Blackwell versus Eskin. Summary judgment proper where record did not contain sufficient facts to support finding of malice despite evidence showing that the defendant may have been negligent for not confirming story with more accurate sources. Bartlett versus Bradford Publishing. Affirming grant of summary judgment where a public figure had failed to prove actual malice because evidence that reporter negligently investigated article was insufficient as a matter of law. And then Judge Alito explained, even as an extreme departure from professional standards. So even if you're a reporter and what you did was extremely unprofessional, without more evidence, will not support. So even if you prove that this news reporter did something super unprofessional, that still doesn't prove actual malice. That still doesn't prove actual malice. It just doesn't. Alito says even an extreme departure from professional standards without more will not support a finding of actual malice. That was in Tucker versus Fishman. Evidence relating to actual malice defense. Plaintiff's only evidence in his testimony that he never had sex with Bree until she was an adult and that he pled guilty to corrupting her just because he should not have been consoling her, which led to her becoming obsessed with him. Plaintiff has no evidence that the Scranton Times or Kelly knew the statement at issue. Plaintiff had sex with a 15-year-old minor, and he admitted to it as part of his guilty plea, were false or that the defendants had subject doubts as to the truth or falsity of these claims. So even if this were true, even if he only consoled her, there's no way that the Chris Kelly and Scranton Combs could have known. Plaintiff testified he has no idea as to Kelly's state of mind when he wrote these statements. According to plaintiff, if Kelly didn't know what he was writing was false, he should have. He describes Kelly's statements as gross negligence. Kelly didn't investigate good enough. That's a quote from Phil. Investigate good enough. I think Kelly relied upon his own Scranton Times article, the article by Dennis O'Malley, and he stopped right there, I think. Godlewski testified in his deposition, I don't have to prove anything. Before the article was published, Kelly realized that QAnon movement was turning into a dangerous thing and that a local guy, Godlewski, is one of the leading voices of the movement. During the month before the article went to print, Kelly checked out Godlewski's videos and postings online. It was Kelly's opinion before writing the article that the Q movement was dangerous. The Q movement challenged objective reality and every institution in this country. Even after Joe Biden was sworn in as president, Godlewski was telling people Donald Trump was still the president. Godlewski was broadcasting nonsensical Q movement theories, and that is why he used the figurative language in the article. Godlewski sells rabbit holes. When Kelly used the word poison in the article, he was referring to the lies, nonsense, and defamation Godlewski was spreading on the internet. For example, Kelly noticed that Godlewski was telling his viewers the real Joe Biden is dead, the body double has been put in his place. So Phil's trying to, when they say purveyor of poison, Phil's almost trying to make a statement like, I don't physically give out poison to people. Yeah, that's a saying, meaning you're poisoning the well or poisoning the conversation or the public's opinion. Godlewski reported on January 6, 2021 that VP Mike Pence had been arrested and he hoped people at the top levels got arrested and executed. The article never stated Godlewski was physically present at the U.S. Capitol on January 6 or had a direct role in the U.S. Capitol riot. Kelly simply believes Godlewski's role in the Q movement as leading proponent helped to fuel the riot. Kelly's investigation of whether Godlewski had a sexual relationship with a 15-year-old girl included his review of archived news articles at the Times Tribune and court documents for the criminal case. Kelly specifically reviewed the 2011 article by Dennis O'Malley under the headline "Ex-baseball coach sentenced for sex with girl 15." He also thinks he also reviewed the criminal court case affidavit and Godlewski's guilty plea colloquy. Kelly's testimony was as follows. And would you agree with me? He did plead guilty to corruption of minors according to the documents, yes. And according to, can you show me where in his guilty plea colloquy he admits to having a sexual relationship with a 15-year-old girl? Ken explained that sentence. That sentence came out of the archives. It came out of the fact that he pleaded guilty to the corruption of minors, and I knew the underlying charges. I believe absolutely and still believe today he had sex with that girl. And everything that's come out since this started supports that. And geez, you know where I was. This was all reported at the time. It was all out there. Kelly further testified, so you relied exclusively on the articles that said he admitted that? Not exclusively. I had those articles. I had the court documents, the affidavit, and I talked to other people, corroborated things that were in those stories with other people. When you read the guilty plea colloquy and saw no mention of sex, did you think maybe you should look further? No, I believed absolutely that the charges is that he had sex with this young girl, and everything I learned since supports that. Well, you weren't there, right? I was not there. You mean in the bedroom? No, I was not. And you've only talked with a friend? No, that's one of the people I spoke with. And the two others that you spoke with you on condition of anonymity, yes. Are either of them eyewitnesses? Again, I don't know whether they ever had sex in front of other people, but these are people who were in a position to know. You're not going to get eyewitnesses for the sex act. I think, in my personal opinion, my professional opinion, as the host of the Cold Beer Confessional, my opinion, Phil's lawyer's retarded. Completely retarded. 100% retarded. Kelly testified, did you attempt to ascertain more carefully the nature of the facts to which Mr. Godlewski pleaded? Yes, I spoke to, and including one of the people I spoke to who was in a position to know and reinforce my belief.
Come bring it at me instead of everybody else.
For real. I was being nice and everything. Let's see how it is. No, I'm an asshole. I don't believe it. I don't believe it. I think I was doing a good job, and you're just a hater. And you're probably putting lean against my problems. What was the name of that porno? Semen Suckers? Splattered and Battered. What was the name of the porno that what's her name was in? Splattered and Battered. That's probably not it. You guys remember what it was called? It's not Splattered and Battered. I made that up. I can't remember the name of it. I'm looking. Where the fuck did it go? The one I said at Elon Musk. Oh, maybe it's under a reply. Okay, it's called Sperm Splattered 4. Sperm Splattered 4. That's what I was looking for. Splattered and Battered. Thank you for the gifted subs. Kelly testified. Did you attempt to ascertain more carefully the nature of the facts to which Mr. Godlewski pleaded? Yes, I spoke to, and including one of the people I spoke to who is in a position to know to reinforce my belief that his plea to corruption of minors was based on his guilt in the sex charges. And that turns out to be true. And I had that again. I went to background sources and got these things confirmed. Someone who was there, someone who understands what happened in the process. And the fact is that he got the victim not to testify, and that is how he got the sweetheart deal. I think that Chris Kelly talked to somebody on the prosecution team, if I had to guess. Thank you very much for the gifted subs. Thank you for the donation. I appreciate that. 1,000 bits. Y'all gotta chill. Mostly peaceful redhead. I see you over there. What, Scott busy tonight or what? Jesus Christ. Kelly also talked to people in law enforcement who corroborated the statement he made in the article. There is no evidence in this case that Kelly subjectively...
Queen just gifted 1 subs.
Thank you. There is no evidence in this case that Kelly subjectively entertained serious doubts about the truth or falsity of his statements in the article. Plaintiff falls far short of meeting this burden to prove the article's alleged false statements were made by a defendant when they subjectively knew them to be false or entertained serious doubts about the truth of them. Even if Godlewski could somehow prove that the statements he complains of in the article are false and defamatory, the defendants are entitled to summary judgment for the independent reason that plaintiff cannot meet his burden under the New York Times of proving the complained of statements were published with actual malice. Again, no, you can't prove actual malice. That's a core tenet here. Actual malice. In an action for defamation, the plaintiff has burden of proving the defamatory character of the communications. It is the function of the court to determine if the publication is capable of defamatory meaning, and if the court determines that the challenged publication is not capable of defamatory meaning, there is no basis for the matter to proceed to trial. To determine whether a statement is capable of defamatory meaning, the court considers whether the statement tends so to harm the reputation of another as to lower him in the estimation of the community or to deter third parties from associating or dealing with him. The court must view the statements in context. It is not enough that the victims of the statements be embarrassed or annoyed. He must have suffered the kind of harm which has grievously fractured his standing in the community of respective society. A distinct standard is applied where the publication is of an opinion. A statement in the form of an opinion is actionable only if it may reasonably be understood to imply the existence of undisclosed defamatory facts justifying the opinion. A simple expression of opinion on disclosed facts is itself not sufficient for an action. So, if I say that, I think this person's a slime ball because of this.
Just gifted 2 subs.
If I say this person's a slime ball because of this or that or whatever, that's not that big a deal. But if I say, and I wouldn't be surprised if somebody looked up and he actually has a bunch of charges for pedos or for kids in his basement because he's a pedo, that would be. Accordingly, Pennsylvania courts have routinely dismissed defamation cases based on statements of opinion. Article that criticized the individual for the way he handled his job, which suggested replacing him, was mere opinion. And while statements in the article might be viewed as annoying and embarrassing, they were not tantamount to defamation. Affirming a grant of summary judgment based on statements and letters that a professor presence in class was an academically deplorable arrangement and that the professor was cavalier in his dealings with students. Another case, dismissing complaint where article conveyed the impression that members of a group were communist. Another case where a statement by chairman and board of supervisors that proposed new building would end up looking like a chicken coop, not capable of defamatory meaning. Another case, statements that plaintiff was adversarial, less than helpful, and uncooperative were not actionable opinions. Under the First Amendment, opinions based on disclosed facts are absolutely privileged, no matter how derogatory. They are Bragg versus Field Communications, quoting 3 restatement second of torts. More cases. That holds true even when an opinion is extremely derogatory, like calling another person anti-Semitic. It still holds true. It's still an opinion. The article includes facts that Godlewski had become a social media patriot reporter with thousands of followers. He was broadcasting that Donald Trump was still the president and working behind the scenes to depose Joe Biden, impose martial law, and bring final justice to elected Democrats and satanic child traffickers. Kelly stated he watched the impeachment trial of Donald Trump, which included video coverage showing many QAnon followers at the U.S. Capitol on January 6. According to Kelly's article, he viewed the videos of the mayhem at the U.S. Capitol on January 6 that resulted in 5 deaths. Kelly's article even noted that Godlewski professed he was not at the U.S. Capitol on January 6. Godlewski did report that day that VP Mike Pence had been arrested. The article references facts that Godlewski did a YouTube show in which Godlewski stated to his audience, "I want a really good explanation. Why would Trump walk away? Why would Donald Trump walk away? He knows there's an election fraud. He has the proof. He has them nailed to the wall, and there's no doubt about that." Godlewski in his YouTube video program went on to say Trump's failure to use the Insurrection Act is actually part of a grand hidden strategy we mere mortals can't begin to comprehend. This is before he claimed he was Q. The article also includes Kelly's opinions that Godlewski sells Q and nonsense to thousands of followers. He is a purveyor of poison. He is one of the citizens of a separate reality who act, organize, and seek to undermine and upend objective reality. That Godlewski calls that out the cadence for the Q movement, and that Godlewski spreads lies. Even plaintiff's wife at the time, Dory Gallagher, thought Godlewski was misleading people and that QAnon is a cult. According to Godlewski, the cabal is a global group of elites such as high-ranking government officials, high-ranking CEOs, and presidents of companies, central bankers worldwide, and other billionaires that control the world without any of its citizens knowing it. Godlewski believes that the government is controlled by the cabal. The cabal operates a global child sex-tracking ring to harvest adrenochrome and for sex purposes. Godlewski preaches about the coming storm when the worldwide military patriots will set humanity free from the cabal's rule. Godlewski's role in the QAnon movement is to provide grassroots dissemination of information of what is happening and the lies of the mainstream media. He labels himself as a highly ranked Anon, short for anonymous, in the Q movement. Godlewski admits he got pretty vocal about Q movement right after the November 3rd, 2020 election. Godlewski grew his viewership and subscribers from 7 to 8 million people to 17 to 18 million people. He earns $50,000 to $70,000 per month from locals.com for subscriptions and advertisements. He earns another $5 million per month from rumble.com. Godlewski did a video on social media claiming Flight 93 never crashed in Shanksville, Pennsylvania, but instead the plane landed at O'Hare Airport in Chicago. The plane is still in use today, according to Godlewski. Godlewski broadcast that Hillary Clinton and her chief of staff, Uma Abedin, were filmed laying children on top of a ping pong table in the basement where the children were molested and frightened so adrenochrome could be extracted from them. This is the main reason why Hillary Clinton was executed. Godlewski claims Hillary Clinton was executed at Gitmo on December 31st, 2018 after a military tribunal. Donald Trump was present for the execution. A body double has been posing as Hillary Clinton since then. Joe Biden was also executed in 2019 after a military tribunal for crimes against humanity. The person elected president in 2020 is not really Joe Biden. He's a body double or a clone. Godlewski asserts Trump's Secretary of Defense, Mark Esper, turned out to be cabal deep state plant and a traitor. Godlewski did video shows stating Anthony Fauci would be arrested and tried by a military tribunal. California Governor Gavin Newsom killed himself, and the person standing in for him is a body double or a clone. Godlewski asserts that the COVID vaccine was developed so that the cabal could control our minds and actions. Godlewski has reported there is really a second secret constitution of the United States, and the Supreme Court of the United States has already rendered a decision overturning the 2020 election, which has not yet been made public. Godlewski broadcasted that John McCain was one of the first persons executed after a military tribunal. Godlewski claims Andrew Cuomo is a pedophile who raped, tortured, and killed children. He declared on social media there is no actual shooting at the court.
78 just resubscribed for 13 months.
Thank you very much. Over a year. Appreciate it. He declared on social media there was no actual shooting at the concert goers at Mandalay Bay in Las Vegas. According to God Lucy, Tom Hanks was a pedophile and executed for military tribunal. God Lucy reported that the District of Columbia has been under martial law and the Patriots have been blown up, that Patriots have blown up the tunnels under D.C. and that were used for child trafficking. President Bill Clinton's chief of staff, John Podesta, is a pedophile who tortured and burned children. Galuski claims the Bush family was involved in a global sex trafficking ring, and George H.W. Bush, the 41st president, was executed. Galuski made broadcasts stating Joe Biden's inauguration in January 2020 was not going to happen. Galuski claimed Biden's election was fraudulent and involved constitutional violations. He wanted the military to correct the constitutional violation. Galuski specifically made broadcasts calling for the execution of election officials who rigged the election for Biden. Galusi claims the people who entered the U.S. Capitol on January 6th were part of the false flag operation. It was an FBI setup to make Trump and his supporters look bad. He reported on January 6th that VP Mike Pence was arrested. Galusi reported Ashley Babbitt was not really shot at the Capitol. He broadcasted that after Arizona decertifies his electoral votes in favor of Joe Biden, the military would take over the country. Galusi got started doing his social media posts and videos a little bit before the November 3rd, 2020 election. Galuski has broadcasted these statements to millions of his subscribers. United States Supreme Court has also made clear that defamation actions cannot be based on statement of opinion. Even Galuski acknowledges Kelly is entitled to his opinions in the following testimony. Okay. The article also says that you traffic in lies, doesn't it? Yeah, look at page 29. Do you see the numbers next to each paragraph? Yes. In the bottom of the paragraph, it said, Galuski is spreading lies across the planet. Is that a false or defamatory statement? It's certainly false. I don't know if it meets the definition of defamatory, but it's absolutely false. Where he's calling you a liar? Yes. And then if you look at paragraph 35, he says the paragraphs, and if you hold yourself as a patriot reporter who tells truths that can't be found anywhere else, don't traffic in lies. So Chris Kelly saying you traffic in lies. Is that correct? That is what he's saying, yes. Is that false? Yeah, especially the part where he says they can't be found anywhere else. I think that shows a lack of research and due diligence on his part. The things that I talk about, I don't actually know what he's referring to in terms of the whole category of traffic and lies. He was never really specific, I don't think, in this article. I think he's just generally calling me a liar and saying that everything I say is a lie. Did you find that offensive that Chris would say that about you? No. I think Chris is entitled to his opinions. God damn it, Phil. Damn it. We can't have a defamation case if you keep approving his opinions and his right to those opinions. You were this close. This close. God damn it. It wouldn't do no good for me to be your fucking lawyer, dude. I'd beat the shit out of you right up on the fucking witness stand. Damn it, Phil. He tricked you again. I don't think that Chris has to believe the things that I believe in, nor do I have to believe the things that Chris believes in. We're free to believe what we want to believe in. The problem I had with the article are the three things that I mentioned earlier. God damn it. Phil. Kelly's opinions about plaintiffs spreading lies and nonsense cannot be the basis of a defamation claim. Like expressions of opinion, mere name calling, or hyperbole. You like that, chat? I remembered. Or hyperbole also cannot serve as the basis for a defamation action. Pennsylvania Supreme Court has recognized that the person who's the target of unkind words is bound to feel hurt, but he or she often exaggerates in his or her mind the extent of damage done to his or her reputation in the public mind. The public has many things to think and talk about. It does not linger on articles which appear in the local newspaper. There you go. Move the fuck on, Phil. It cites a bunch of cases. It says portrayal of a figure as vile, obscene, abusive, intensive, and paranoid, not defamatory. So you can call somebody vile, obscene, abusive, intensive, and paranoid, not defamatory. Pennsylvania Supreme Court in particular has recognized that criticisms, hyperbole, and opinion directed at public officials are not actionable defamation. In deciding whether or not a publication is defamatory, courts should be guided by America's profound commitment to the principle that debate on public issues should be uninhibited, robust, and wide open, and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on the government and public officials. The constitutionally protected area of free speech revolves around the freedom to criticize government and the officials responsible for government operations. To prevent a chilling effect on the Supreme Court of Pennsylvania has held that statements which represent differences of opinion or are annoying or embarrassing are without more not libelous. Neither is the statement libelous, which is no more than rhetorical hyperbole or a vigorous epithet used to describe what the publisher believes to be another's extremely unreasonable position. Kelly's opinions about Godlewski are well-founded and not defamatory. Certain statements in the article are protected under the fair report privilege. The fair report privilege provides the news source has a qualified privilege to make a fair and accurate report of official governmental reports or proceedings if the publication is not solely made for the purpose of causing harm to the subject of the report. The privilege is premised upon the theory that if it is in the public interest, that information be made available as to what takes place in public affairs. The fair reporting privileges do not require that a publication contain verbatim recitation of the subject matter of the report, but only requires that the article provide substantially accurate summary. The statements in the article about plaintiff's conviction on the corruption charge concerns a criminal complaint and a guilty plea entered by the Court of Common Pleas of Lackawanna County. The detective's allegations about where Godlewski had sex with the minor victim came right from the search warrant served on plaintiff. Plaintiff has admitted the detective served him with a search warrant and affidavit, did allege he had sex with a minor in cars and in houses he had access to as a realtor. Because the article reports on court records from an official judicial proceeding, these particular statements are privileged. Binder versus Triangle Publications, privilege extends to accounts of judicial proceedings. So, if it's a public affairs thing going on, like a court case or a meeting or something, you're allowed to talk about it as a reporter, even if you don't quote it verbatim, as long as it's overall accurate, right? You might know every word that was said, or you might not, some words might be unintelligible and you think you know what they were, but they weren't, right? And that's fine because it doesn't have to be word for word. Damn. We made it far enough yet. We're at 57. Plaintiff has insufficient evidence to prove loss of reputations or actual injury for his defamation case. A plaintiff alleging defamation has a burden of proving damages. Every defamation plaintiff must prove actual harm. The plaintiff must demonstrate whether the statements in the article tend to so harm his reputation of another as to lower him in the estimation of the community or to deter third parties from associating or dealing with him. Tucker versus Philadelphia. The Pennsylvania Supreme Court has held it's not enough that the victim of the statements be embarrassed or annoyed. He must have suffered the kind of harm which has grievously fractured his standing in the community of respectable society. Godlewski has failed to present evidence showing the existence of damages, special or otherwise, to overcome defendant's summary judgment motion. At the outset of this case, defendant served plaintiff with interrogatory set 1, and plaintiff responded to these interrogatories as follows. Identify all persons who you believe have an unfavorable view of your reputation due to the February 14, 2021 publication. The interrogatory is objected to on the basis plaintiff cannot possibly meaningfully respond to this question at the juncture of the proceedings. Well, that's bad because now's the time to respond. So that's a horrible response, you fucking retard. Identify all recipients of the alleged defamatory statements who have exposed plaintiff to public hatred, contempt, or ridicule. This interrogatory is objected to on the basis that plaintiff cannot possibly meaningfully respond to this question at this juncture of the proceedings. By way of further, to answer, the defendant has access to the number of views that the Scranton Times Shamrocks receives.
Just gifted 5 subs.
Thank you for the gifted subs. Times Shamrocks receive from the digital advertising, share buttons via their website, Facebook, and other social media, views, shares, or newspaper sales or analytics. The reason this doesn't work, the reason he just can't look, the reason he just can't see, like look and see how many times the article was shared or how many times whatever, is because those people might have already hated Phil. I hated Phil already, and I read the article. Hell, I might have even shared it. I don't know. Identify any persons who refuse to do business with or associate with plaintiff as a result of the article. This interrogatory is objected to on the basis plaintiff cannot possibly meaningfully respond to this question at this juncture of the proceedings. By way of further answer, the defendant has received hundreds of threats and harassment on social media from anonymous users, which spiked after the article was released. In addition, plaintiff was terminated from his real estate job after the article was published. Both these things are not true, or at least he didn't present evidence of them. He did not present evidence that he lost his job because of this article. He did not present evidence of any of these threats. Identify any persons whose opinion of the plaintiff's reputation was affected by the article. See answers 37 to 39 here and above. State all damages suffered. Uh-oh.
Small dick, but wait till it get hard. She gonna be like, damn, shit, my God.
Thank you for the donation. State all damages suffered or claimed by you in this case and how the damages were computed and all facts supporting each claim. This interrogatory is objected to on the basis the plaintiff cannot possibly meaningfully respond to this question at this juncture in the proceedings by way of further answer and no way in derogation of the foregoing. Plaintiff is claiming to so far unspecified damages for pain and suffering and for damages to his reputation, including punitive damages. Plaintiff is also claiming economic loss and having been released from his job as an independent contractor and real estate professional at ERA One Source Realty because it received complaints and hate mail directly related to the article. Additionally, plaintiff's online reputation has been severely damaged and he is being libeled online as a pedophile. This started after the article was released. Bullshit. I started before the article was released. Defendant served a request for production of documents set 1 upon plaintiff, which he responded to as follows. Exhibit 37, number 8. Any documents evidencing harm to your reputation, lost earnings, diminished earning capacity, embarrassment, and or humiliation caused by the article referenced in the complaint. Answer. Plaintiff is in the process of collecting them. There are literally hundreds of messages, screenshots, online comments, hate emails, hate mail, and other documents evidencing the damage to plaintiff's reputation. Gathering all of these will likely take some time. No such documents have ever been provided, and discovery is now closed. Phil claims that he had hundreds of messages, screenshots, online comments, hate emails, hate mail, and other documents evidencing the damage to the plaintiff's reputation. Gathering all these will take some time. No such documents have ever been provided, and discovery is now closed. Plaintiff then provided supplemental discovery responses 38 to 42, which he again provided no proof of damages. His supplemental answers were as follows. Plaintiff cannot provide a complete list. A sample of the individuals who now have an unfavorable view of his reputation were provided by your client. However, the plaintiff intends to do some statistical research and find out how extensive this is. This has not been undertaken as of yet. Further, plaintiff believes that in his industry, selling real estate, his reputation has been significantly harmed. Once again, plaintiff intends to research this issue more carefully. In short, plaintiff does not have a complete answer to this point. Still hasn't answered, right? I'm going to do some statistical research and get this figured out. 39, see answer to 38. 40, obviously ERA is no longer doing business with plaintiff. 41, see answer to 38. Plaintiff did not supplement the responses to number 8 of requests for production of sets of documents. Godlewski's own testimony is as follows. God damn it, Phil. What did you say now? What did you fucking say? Phil, do you have any persons that you were friends with before the article that said, Phil, I'm not going to be friends with you anymore because I read what Chris Crowley wrote and I believe it? Tim, that's not something that happens in real life. People don't come to you and say, hey, I'm no longer going to be friends with you because of an article that I read. They just stop talking to you. And yes, that has happened dozens, if not hundreds of times with my friends from high school, people in the area that I used to do business with many times. Can you name them? You just asked me that 4 times in the last 5 minutes. Well, just now, I just remembered one. So happens. Who is it? I was still doing real estate, and it was Freddie Gray. Freddie Gray, okay? Freddie Gray. Do you guys know who's quoting here? I don't know if this just popped into his head or what, but Freddie Gray was the guy who got arrested by Baltimore cops over illegal possession of a knife and died in custody. Oh, Freddie Gray. I remember him. I remember Freddie Gray. Yeah. He was up in Baltimore, I think, and he don't like me no more. Who else? George Floyd. Oh, George. Me and George went to school together. When I first read this, I laughed so hard that he named Freddie Gray. It was Freddie Gray. Freddie Gray had a house on what the heck street was that? An Old Forge with his wife, Emily Gray. They canceled their listing with me. A $200,000 house. Again, I'm not suing for economic loss. You know that. And you said that. I'm suing for what damage that your article has done to my family and me over the... God damn it, Phil. You keep giving it up, buddy. Jesus Christ. However, as the Pennsylvania Superior Court has declared, injury to reputation is judged by the reaction of other persons in this community and not by the party's self-estimation. Godlewski's personal beliefs about his reputation are not sufficient evidence of damages. Plaintiff has already stipulated he has no economic or special damages. The court entered an order on January 8th, 2023, dismissing such claims. Godlewski's mere conjectures fall short of the standard of specific facts showing damages. See Curran versus Children's Services Center of Wyoming County. To avoid summary judgment, the non-moving party must set forth specific facts demonstrating that a genuine factual issue exists. Plaintiff has not taken deposition of Sunita or Aurora or ERA, One Source Realty. This is how he would prove that he was fired for the article. You need to go to Sunita, who is the woman that loaned him the money after he bounced a $21,000 check, or someone in, HR at ERA One Source Realty, and prove that you were fired for this. And he didn't. Plaintiff, he claims he was fired by Sunita Aurora by an email, but he has never provided the defendants with a copy of this email. Sunita Aurora let Godlewski go from his real estate job because of his QAnon videos. That's weird. That's weird because it was supposed to say Chris Kelly's Scranton Time article, but it ended up saying QAnon videos. See how those two get confused? Plaintiff claims he lost one real estate listing with Freddie Gray and his wife, Emily Gray, due to the article. Plaintiff never deposed Freddie Gray or his wife. Well, he's dead. Nor did he obtain an affidavit from either of them. Defendants did obtain the records on Freddie Gray's sale of his house and divorce from public offices. A true and correct copy of the recorded deed of transfer from the Grays or the grantees and a copy of Gray's divorce decree are included in exhibit list and marked as Exhibit 46. Freddie Gray and his wife sold their house and were divorced before the article was even published. God damn it, Phil! God damn it! They sold their house before the article even come out? You couldn't think of one fucking person that's not your mom or your dad that would be on your side? You were this close, Phil. You were this close. We almost had it. You were this close. You can't think of... Oh, Freddie Gray. Me and Tim's good friends. Phil, they sold their house in 2010. Yep, that's what I'm saying. Plaintiff admits he had less than $200 to his name when the article was published. Now he claims he's worth $75 million and he earns... Remember when I said they're not going to dispute him embellishing how much money he makes? This is why. They know he doesn't make that much money. They know he's lying through his ass. They didn't even ask him to prove he made that much money. Why? Why? Because it makes them look better and he's fucking retarded. He can't stop bragging. Plaintiff admitted he had less than $200 to his name when the article was published. Now he claims he's worth $75 million. He earns over $5 million per month. Godlewski has not named anybody who read the article, believed the alleged false statements about him, and has treated him differently. Godlewski simply claims his damages are unquantifiable, and he is suing for the harm to his family and his potential loss of business. Plaintiff has admitted he was a bad person until he went to jail in the summer of 2021, 5 months after the article was published, and found God. He has met the love of his life after his release from jail. He likes his career now, and he's never going back to real estate. He has been on Zoloft since 2018, and it helps him with anxiety and depression. Zoloft keeps him in a good place, and he is doing fine. He has no mental health treatment since June of 2021. He treated with mental health providers in May and June of 2021 due to his marital issues and an upcoming sentence hearing for guilty pleas on a bad check and tampering with bank record charges. Dory Gallagher, his wife at the time, testified she filed for divorce in March of 2021, mainly due to Godlewski's infidelities and his involvement in QAnon, which she described as a cult. Dory is 3 years and 4 months younger than Godlewski. And Godlewski cheated on his wife, Dory, with an employee at his real estate company named Miranda. Dory found out about the affair with Miranda. Godlewski left the marital home for about 2 weeks. Miranda is the same age as Bree, 10 years younger than Godlewski. God damn it, Phil! God damn it! All you had to do, all you had to do is fuck somebody your own age. Now it's like you have a top. God damn it! You need to pay your lawyer more. I'm already aggravated. This is ridiculous, Phil. Are you shitting me? Miranda is the same age as Burry, 10 years younger than Godlewski. Dory admits Godlewski is attracted to younger females. Oh, fuck. Godlewski fired Miranda for telling Dory about the... God damn it, Phil! God damn it. Not only did you sleep with her, you fucking fired her afterwards.
Drunk, I'm a little bit drunk.
Love your dramatic readings, Will.
Thank you for the donation.
I'm a little bit drunk, cause I'm drinking.
Me and Levada's mad as hell about this. Mad as hell about this, okay? Levada's like, he fired her? Yeah, he fired her. The real estate agency ended up having to pay Miranda $11,000 because of her firing. God damn it, dude. What do you do? You're like the worst person to ever go to court, right? You're like the person who gets away with murder and then fucking sues the DA for charging you with murder, and then while you're up on the witness stand, the bloody murder weapon falls out onto your lap. And you're like, "Oh, that's my murder weapon knife I keep in my coat. Take that away for me. Here, you guys want it?" Oh, God. Dory filed for divorce from Godlewski on March 8, 2021. Just 23 days later, Godlewski wrote a text message to Bree, which stated, "Meh, I'm good. I feel better that she's gone, to be honest. The sex sucked or was non-existent, but always one of the two. She was constantly miserable. She wasn't even really a great mother. The kids always wanted to be with me and not her. It was a disaster." Sure. Incredibly, in this case, the plaintiff is trying to blame the defendants in the article for Dory leaving him. Before she left the marital home in February 2021, Dory asked Godlewski to stop doing social media videos. She thinks his videos are crazy and he is lying to people. Dory agrees Godlewski is a QAnon realtor. The Q movement scares her. She requested Godlewski only have supervised custody of the children because of his QAnon beliefs. Damn. God damn it. Phil. No. Godlewski's false light claims fares no better than his defamation claims. The tort of false light, invasion of privacy, involves publicity that unreasonably places the other in a false light before the public. A cause of action for invasion of privacy will be found where a major misrepresentation of a person's character, history, activities, or beliefs is made that could reasonably be expected to cause a reasonable man to take serious offense. The elements to be proven are publicity given to private facts, which would be highly offensive to a reasonable person and which are not of legitimate concern to the public. So this claim is you take something, you give publicity to something that's private. So like, let's say I write an article and say, you guys might like Mayor Joe, but did you know he's a fucking swinger? And I have like this hidden photos of him at like this fucking key party just getting railed the fuck out by some big black dude or something, right? And I publish that. Like, that's private facts. This is all public. This doesn't even apply at all. None of this applies. This is all public. None of this applies. Given to private facts, which would be highly offensive to a reasonable person, which are not of legitimate legitimate concern to the public. A false light claim also requires actual malice where the plaintiff is a public figure. C3, restatement, second of tort. In order for plaintiff's false light claim to be successful, plaintiff must show a highly offensive false statement was publicized by defendants with knowledge of its falsity or its reckless disregard for falsity of the statements. None of the statements made by the defendants were false. Many news articles had previously described plaintiff's involvement with a minor victim. Godlewski's failure to prove actual malice, as discussed above, dooms this claim as well. Plaintiff's claims of interference with existing and prospective contractual relations. In count 5 of the complaint, plaintiff alleges defendants wrote the article knowing its effect would be detrimental to plaintiff's reputation and therefore his ability to make a living as a realtor. Further, plaintiff claims that the article was published to hurt plaintiff's relationship with his current employer and that he was terminated from his position as a realtor as a direct consequence of the article. In count 6 of the complaint, plaintiff asserts that defendant's article was intended to harm plaintiff's prospective contractual relations with potential real estate clients and other realtors. To make out a cause of action for intentional interference with a contractual relation, a plaintiff must demonstrate purposeful action on the part of the defendant specifically intended to harm the existing relation or to prevent a prospective relation from occurring. None of this happened, right? They didn't purposely go out and try to prevent him and try to make him lose contracts or prevent him from getting future contracts. Supreme Court of Pennsylvania established the 4 elements to prove a cause of action for intentional interference with prospective contractual relations. The elements are a prospective contractual relation, so he hasn't even proven that he has any contractual relationships. The purpose or intent to harm the plaintiff, preventing the relation from occurring. The absence of privilege or justification on the part of the defendant, and the occasioning of actual damage resulting from the defendant's conduct. The elements of this tort of inducing breach of contract or refusal to deal are: one who, without a privilege to do so, induces or otherwise purposely causes a third person not to perform a contract with another, enter into or continue business relationship with another, is liable to the other for the harm caused thereby. So if you had like a contract with like a, I don't know, with like a trucking company, and I went to them and told them like every trucking company he's ever had, like he fucking sues them. He lays down behind the trucks, and then when they back over him, he sues them and says they were fucking negligent. And it was a lie. That would be it, right? That would negate that contract. In other words, the actor must act for the purpose of causing this specific type of harm to the plaintiff. Such act must be unprivileged, and the harm must actually result. Godlewski testified he has no intention of ever going back to being a realtor. I like my career, I like my lifestyle. Godlewski God damn it, Phil! You said they fucked up your contracts and you don't even want to be a realtor anymore? Godlewski testified his income has gone up since the article was published. He specifically said, I'm not suing for economic loss. An order to the court has been filed in this case dismissing all plaintiff's claims for economic damage. Godlewski had his real estate license revoked. God damn it! You don't even have a license to be a real estate agent. I forgot about that. Due to bad check and tampering with bank records convictions, his testimony on that subject was, so I wasn't going back to real estate anyways. Whether or not they revoked it or suspended it was irrelevant to me, so I just let it go. Plaintiff earned $136,000 in 2020 as a realtor. Plaintiff earned over $5 million per month now as a social media reporter and influencer. Plaintiff has no evidence of actual damages or harm in order to move forward with counts 5 and 6. Counts 5 and 6, based solely on alleged interference with the real estate work, they must be dismissed. Plaintiff cannot meet this burden of proof to prove punitive damage. Under Pennsylvania law, to prevail on a claim for punitive damage must not only establish actual malice, which is essential element of their claim for defamation, but also common law malice. In Dizella v. PG Publishing Company, the Pennsylvania Superior Court, after an extensive analysis, stated, we hold that a public official, public figures are treated the same, who must prove actual malice to establish liability in defamation action may not also recover punitive damage. Damage is absent of an additional finding that a defendant acted with common law malice in its publishing the defamatory statement. So if you're a public figure or a public servant or public official or whatever, and you have actual malice clause, you cannot get any punitive damages unless you already proved that actual malice clause. See how that works? The court has since reaffirmed the holding. To recover punitive damages in defamation, the plaintiff must not only prove actual malice, but must also demonstrate that the defendant acted with common law malice. So it's actually a higher standard. You have to do both, actual malice and common law malice, in publishing the defamatory statement. Under Pennsylvania law, common law malice involves conduct that is outrageous because of the defendant's evil motive of his reckless indifference to the rights of others, and is malicious, wanton, reckless, willful, or oppressive. In determining whether a particular defendant's conduct displays the necessary degree of evil volition, that's a new one, evil volition, the focus is not on the nature of the category of the tort, but rather on the defendant's deposition towards the plaintiff at the time of the wrongful act. Before punitive damages will be allowed in a case involving the defamation of a public official, the plaintiff must prove the defendant displayed actual or apparent ill will. This is so because punitive damages in public official defamation actions are specifically intended to punish and deter publication with actual or apparent ill will. Proper application of the common law malice standard assures that the media defendant's rights are sufficiently protected under both the First Amendment and the Pennsylvania Constitution. Accordingly, even where a public official shows actual malice, punitive damages cannot be awarded except upon proof of common law malice. You have to have both. Upholding a trial's court refusal to give punitive damages instruction despite showing of actual malice. As set forth above, plaintiff cannot meet his burden of proof showing actual malice or common law malice. Therefore, his claims for punitive damages fail as a matter of law and should be dismissed. And we're going to wind her all up right here and put a fucking bow on it. Conclusion. The article discusses the QAnon movement and its detrimental effect on society, which is a matter of public concern. Plaintiff admits he's a public figure, and the court has entered an order declaring him to be a public figure. By his own admission, plaintiff is the leading voice for the Q movement. Plaintiff has made a good living on social media peddling lies and conspiracy theories. The central focus of QAnon believers is it's a war on the worldwide cabal of pedophiles. A common definition of a pedophile is an adult who is sexually attracted to children. There's a substantial amount of evidence referenced herein indicating Godlewski fits this definition. God damn. There's a substantial amount of evidence referenced herein indicating Godlewski fits this definition. Bree was a child when Godlewski had sex with her. His story about why he pled guilty to corrupting a child makes no sense. The Scranton Times is entitled to summary judgment because plaintiff cannot meet his burden of proof, falsity, and actual malice for publishing the article. Additionally, plaintiff claims based on statements which constitute Kelly's opinion or statements that are not capable of defamatory meaning must be dismissed. Plaintiff has also failed to produce any witnesses that understood the alleged statements were defamatory, and he has no evidence of suffering actual injury or harm from the article. Plaintiff must present evidence of an injury to his reputation, and he has failed to present such evidence here. Defendant respectfully requests that this case be dismissed with prejudice. Phil's been splattered and battered, boy. Oh, that's pretty good. Tim Hinton. Thank you very much, Tim Hinton. Shout out to Tim Hinton. Tim Hinton's going to be the most in-demand lawyer. If Phil loses this and just lashes out and starts suing everybody, Tim Hinton's going to be the most in-demand lawyer in the world. I hope he writes a book after this. I hope he comes on the podcast after this. Fuck. Thank you guys for joining us. That's Phil's current legal troubles. Doesn't look like he's winning this one, folks. Doesn't even look like it's going to court. Thank you all for joining us. I'm going to keep it short to put it together. Thank you for the donations. If you like the show, if you like what's going on, 17 that's a great show. Thank you very much. If you like the show, you want to keep it going, you want to appreciate it, it's cheaper than cable. Go to coldbeer.fund, make a contribution to the show, coldbeer.fund. I got to keep this short, so maybe some of his followers will actually watch it. Thank you guys for joining us. I'll see everybody on the next one. Be back tomorrow. Love you. See you. Bye.
But I can tell you this about if this douchebag happens to see this particular show.
Just when you thought he was going to win. I mean, just when you thought he was this fucking close. God damn it, Phil.
Exactly who they are.
Told on yourself, buddy.
Yeah, you don't have the forking balls. You don't have the balls.
Hashtag same team.
Here we go, I think I started some shit. Listen off, it's about to get lit. Get the place in the best, you know that stage is set. You better buckle up, cause you ain't seen none yet. Here we go, I think I started some shit. Listen off.
I do know there was supposed to be a Patreon video tonight, but we just have to move it. Sorry. This all came out and I needed to cover it. Everybody else was, so I'll move the upper tier Patreon video. We'll move it to the weekend or something.
Y'all need Jesus.
So you're saying there's a chance?
All these fucking prophets who profit off of gossip, worshiping drums, cocking, begging for a throat deposit, swinging fucking meat hammers like Thor in a thong. He's strapped to the shaft, beating his chest like he's.
God damn it, Phil.
I'm gonna make your gut burst.
That should be his slogan.
I can't quench that thirst. Baby eating lizard people, alien sex. What's next? Trump in a dress, fucking Flynn on his desk. A retard in a vest, climbing up 5G towers. Cause you told him if he did, he'd get fucking superpowers. Here we go, I think I started some shit. piss them off. It's about to get lit. Get the place in the best. You know that stage is set. You better buckle up, cause you ain't seen none yet. Here we go, I think I started some shit.
What do you think the chances are of a guy like you and a girl like me ending up together?
Well, Lloyd, that's difficult to say. We really don't...
Hit me with it. Just give it to me straight. I came a long way just to see you married. Just, least you can do is level with me. What are my chances?
Not good.
You mean not good like 1 out of 100?
I'd say more like 1 out of a million.
So you're telling me there's a chance?
Phil at court next week. Have a good night, everybody. You guys are going to have to stop using that fucking emote that's got Lavada on it. Madison Marquette's looking for him. She's been splattered and battered.